I'm mentioning item number 26 on behalf of Mr. Tara. He couldn't make it today due to personal obligations. Item number 26. I have obtained consent, Your Lordship. The matter may be listed after 2 weeks. Item number 26.
Mr.
26.
You are Mr.
P. Ronia on behalf of Mr. Tara.
Land Council, appearing on behalf of Mr. P.T. Tara, Land Council for the appellant. What is the reason you said?
Due to personal obligations, he couldn't make it.
Okay, Mr. So some is that the conducting council, Mr. P.T. Tara, Land Council for appellant, would not be present today due to personal obligation. Therefore, pray for adjournment of the matter for 2 weeks. The council has also obtained consent from the land council appearing on behalf of the other side. The prayer is allowed. The prayer is allowed. List this matter after 2 weeks. Okay.
Obliged, sir.
Lordship, item number 23 and 24. This matter has been wrongly listed here, Lordship. It should have been before the court one. Because this is a bail matter rejected by the Justice Atta.
Okay, 22,
23 and 24.
23 and 24.
Yes, as per the standing notification, the
Okay.
same court has the power
22 and 23, huh?
for tomorrow.
Okay, list this matter before the appropriate bench
Tomorrow.
tomorrow.
Yes.
Okay.
23 and 24. 23 and 24.
Please, Your Lordship. Lordship, I have taken consent from the other side. I'm mentioning for item number 24. This matter may be taken after
20?
Item number 4. This matter may be taken after 2 weeks, Your Lordship. Item number 4.
After 2 weeks.
Yes.
Mr. A. Bhattacharjee, Land Council for the petitioner. Why after 2 weeks?
Opposite side, Mr. Tado is also not present, and I have seen this matter on just this morning in the course list.
Okay, Mr. A. Bhattacharjee, Land Council for the petitioner. Some says he has some personal difficulties today, and they are prepared for adjournment of the matter for 2 weeks. The prayer is allowed. List this matter after 2 weeks.
Much obliged.
Okay.
May I please, Your Lordship?
My lord, I beg to mention item number 27. I'm on behalf of Uttam Deka. He is out of station, and the consent has been taken from the opposite party. So, Lordship, kindly matter may be fixed on 17th of this June.
Mr.
T by
Levi.
on behalf of you, Deka.
So you, Deka is not here today. Appearing on behalf of Mr. U. Deka, Land Council for the appellant, with the consent of the Land Council for the other side, prays for adjournment of the matter for the day. The prayer is allowed. Please this matter. You are for?
I'm for the respondent, Your Lordship. Respondent.
No objection.
No objection, Your Lordship. This is a joint prayer. Kindly, this matter may be fixed on 17th of June.
Okay. Pray for adjournment of the matter for 2 weeks, to which Mr. Kambo, Land Council for the respondent, has no objection. Prayer allowed. List it matter after 2 weeks.
Can it be on fixed, Your Lordship? Fixed it? Can it be?
When?
17th of June.
Okay. The prayer is allowed. And as requested, list this matter on 17th.
Okay. Yes.
Okay.
Obliged.
Obliged.
My lord, I beg to mention item number 12, 13, and 14. My lord, with the consent of the other side, my lord.
Who is? Yes.
My lord, with the consent of other side, my lord, I beg to mention item 12, 13, and 14.
This matter will be listed after 2 weeks. Since Mr. Elbam is the leading counsel in this matter and he is out of station. Mr. Ibam. Not counsel, submit that. Who is the leading counsel? Lemi Bam. Mr. Elbam. The leading counsel for the appeal. Mr. Elbam is out of the station. Therefore, pray for adjournment of the matter for 2 weeks. Yes. He has also obtained consent from the land council of the other side. The prayer is allowed. List this matter after 2 weeks.
Very Lordship. Lordship, I beg to mention item number 21.
Item
21. Lordship, in this matter, PCR has been arrived. So Lordship, matter may be listed for admission hearing. I have
okay,
taken.
we'll see. This is in order. We'll see the record and pass order, necessary order. Okay.
Okay. Oh, Lordship.
My lord, may I please your lordship?
Side for it.
Register on the 21B.
21B.
Your Lordship, what is this? Page 14 is order.
Phase 14 is forwarding report. Forwarding of the accused person before judicial magistrate.
How it is forwarding page 14.
Page 4. Page 14 is a rejection order.
When it was rejected.
It was rejected on 3/6/2025,
Yes,
Your Lordship.
Why
was
it was rejected? On what ground?
It was rejected by observing that there is an incriminating material against the
Okay.
accused person.
Then what happened thereafter?
Thereafter, Your Lordship, this is the subsequent bail application.
So what is the new ground that you have?
Your Lordship, I have taken here 3 grounds. The
Yes.
first ground, Your Lordship, the ground of arrest. Second, non-comply of section 50. And the third ground, Your Lordship, I have taken is the medical ground. Your Lordship, with regard to the ground of
No,
arrest.
that was also taken care of. I think the section 50 also discussed, it appears.
Your Lordship, section 15 was discussed, but however, Your Lordship, there is no notice, Your Lordship.
Section 50 and your medical ground was also considered.
No, not considered, Your Lordship.
That's not rejected.
Your Lordship, here, the seizure is also doubtful, Your Lordship. Because Your Lordship, here, Your Lordship, arrest was made at 8 hours and the recovery, the seizure was made after 12 hours. At 20 hours, Your Lordship. And in the seizure memo, Your Lordship, there is no signature of the magistrate. As per the law, the seizure has to be made on the spot.
Section 50 also served. Notice under section 50 also served.
Your Lordship, when will
There is incriminating material because it was seized from the possession.
Your Lordship, when we look at the
Council, immediately after rejection of the bail, after appreciating the materials on record, then how do we reconsider and reappreciate? Immediately after rejection of the trial court, this is trial court. The trial court is the best court. We can consider whether the eligible person is entitled bail or not. Now, how do we reconsider immediately after rejection?
Your Lordship, here, Your Lordship, the mother of the accused person is severely, Your Lordship, his health condition is deteriorating each day.
That cannot be the ground.
Your
for
Lordship,
the
he is the only person in
release
the
of the
family.
accused in the NDPS case.
And Your Lordship, if we look at the seizure memo, Your Lordship, there is a doubtful, Your Lordship, regarding the stage of the contraband substance from the possession of the accused person.
See, only the forum change, same thing, same situation, not changed.
And Your Lordship,
Subsequent,
new
the
ground I
fact
have-
of the case cannot be changed by filing subsequent bail application immediately, one after another.
Your Lordship,
Yes. Mm.
Case study may be called for lordship, then we'll see lordship
Pardon?
status.
Pilaji. Your
M.
M.
Kamcha,
M.
M. Kamcha.
Kamcham, Land Council for the petitioner. So, this is an application filed under section 483 of the BNSS 2023, praying for release of accused Sheikh Farid, who has been arrested by the Nahalagan police in connection with Nahalagan PS case number 62, 2025, under section 21B, stroke 29 of the NDPS Act 1985. Issue notice. Since Ms. El Hage, Land Additional PP, appeared and accepted notice on behalf of the respondent, state no notice required to be issued. So, call for the scanned copy
Scanned
of
copy.
the, that will be case diary only,
Case study lordship.
case diary. List this matter.
Next week lordship, after a week lordship.
On
May 2025, my family member was surprised when the police has visited my house, and immediately I got the information from my family member that allegation is that some Khoda Raja already lodged an affair on 6/12/2019 and stated that some dealers money was fraudly by me, and allegation, as per allegation, kindly come to the page affair number, page number 15. Page number 15. May I read?
yes.
That the affair is lodged before the authority against one Sri Anup Borua, who is seated me and some of the customers. He is serving sales executive in Itaford, Ford dealer. He has committed criminal breach of trust, fraud, cheating by forging and using the dealer money received without my consent and misappropriating the money of the company. Hence, the authority of this concern may initiate a necessary criminal proceeding against the aforesaid person by immediately detaining the person mentioned above and book under relevant mention of code. It is informed you that on 2/12/2019 around 9 a.m. one of my staff furnished a copy with a money receipt of Itafort dealer amounting rupees 50,000 and rupees 17 lakhs respectively. Upon inquiring about the matter, it is found that Sri Anup Borua has used the company's money receipt book and used is a concealing manner for personal gain. The company's money receipt from is kept with the accountant, but how it can in his hand, it is not known. Apart from that, one person who also made a complaint that he has paid 4 lakhs in the personal account of Anup Borua to obtain card EcoFort, but after transferring the amount of paid away, there is no further report in this concern. He is misusing the company's. He is in Guwahati. These are the my lord allegation. And after allegation, police registered the case, white case number 95 of 19 in Mirjuli, PS case number under section so and so so and so. My lord, these are the facts. Main facts is when the police visited my house on 26th of May 2015, immediately I am approached before this High Court on 27th of May, last May, for getting the certified copy. What is the real fact? After getting the certified copy, we got no some, these are the allegations against me. Now, my lord, main fact is that at that time, when the FIR was lost 2019, I was working as a consultant, not the sales executive. My work is at that dealer to submit the report to the company directly, not the related any customer or any financial matter. All the financial matter are looked by the account department. And my lord, kindly see, the order was passed in 2019 and NVW issued against me in 2020. But from the date of 7th of January 2020 to till now, 26th of May, no any charge sheet is filed against me and no any personally laws against me by the allegation made by the MD of the dealer. My lord, suppose
You have not been arrested.
yes, my lord, I am
How,
not.
how the charge sheet can be filed?
That's why, and
You
not.
remain absconding.
No, my lord. I am staying at person in the middle of the Guwahati, and I am personally I am residing at Guwahati, and from the beginning, from the by birth till now. But my lord, kindly see, FIR was lost in 6/12/2019, and honorable court, thus which is pending the court and CGM order passed in 7th of January 2020. Police were totally failure, and no any evidences were required against me that some allegations are made by them, and no any personally evidence. Even my lord, kindly see, look after again, my lord, kindly see the page number 15. The informant categorically stated there, the accounts department, the company money received from the kept with the account department. It means wholly account department look after the financial matter, and how it can in his hand, it is not known. My lord, these financial matter are looked by the account department, not by me. And main important thing is that, my lord, at that time, 2019, my lord, the COVID pandemic destroyed the whole world. Honorable Court knows very well. Subsequently, at that time, the dealer of the Ford company left away India due to some technical problem. And at that time, their failure to subsequently give the salary of the employee. That's why I'm leave the job, and permanently now I'm settled in Guwahati. And my lord, as per the allegation, they are not mentioning who are the person to give the account, who are the person to.
Yes, we call for the.
Yes, Your Lordship, CD may be called for, however, Your Lordship, with regard to interim, I may state that since the non-bailable warrant was issued in the year 2020, there might have, because to consider him as a proclaimed offender, Your Lordship, this is the first step for issuing a non-bailable warrant of arrest, Your Lordship. That has not been annexed along, Your Lordship. So through the CD, if that is the case, Your Lordship, he is already declared as a proclaimed offender, Your Lordship. In that case, he is precluded from approaching this court with anticipatory bail, Your Lordship.
My lord, kindly see, my lord, my prayer is so limited, my lord. 7 January 2020, FIR was lost, and the CGM Honorable Court passed an NBW against 2/5/2025. But without any notice from the police, without any call, how can I know that there's some allegation are made against me? When police visited my house, immediately next day, very next day, 27, I am coming here to got the certificate copy. And kindly see the certificate copy dated, my lord. In FIR, I have collected the certificate copy of 26.
Now, see, if you appear before the police and clarify that you are innocent,
Yes, sir.
then the police also will not arrest you.
Yes, if I am appear,
But you remain absconding since 2019.
no, my lord, I am not absconding because I am staying in Guwahati. I am a well-settled businessman and my house is the middle of the Guwahati. Police knows my addresses, but no any contact, no any message or 41 notice to me from that 19 to 2025.
Mr.
Arkenath,
Council Putra.
kindly protect me, my lord, till the next date, my lord.
Hmm?
Kindly protect me till the next date, my lord.
You have been, you see, you remain,
Arkenath.
you have been protecting yourself for 7 years. Protect for at least
No, my lord.
for 1 more week. This is an application filed under section 482 of BNSS. Just a minute. Okay. Just a minute. By filing this application under section 482 of BNSS, the accused applicant is seeking grant of pre-arrest bail, apprehending his arrest in connection with the Nirjuli PS case number 95, 2019. Okay. So GR case is also.
Yes.
Under section 406, 408, 419, 420, 427 of IPC. We'll just see what is the progress.
No such state has been filed, my lord. Till now. And my lord, we know the facts on 26th of May 2025, and immediately we are filing the certificate copy and approach before this honorable court by way of this petition for relief, for the end of justice. My lord, I have 2 minor children and my old parents, my lord. I am stayed in Guwahati permanently in immobile property. I have no any chances for absconding, my lord, because I have no ever about the facts. Main thing is that FIR is lost on 2019 and I got the information at 2025, my lord. I received the notice 26th of May. We received the notice from the police 26th of May when they are visited my house. And we immediately come to the Arunachal, madam.
Where you were working in the.
Yes.
Till.
I am working at that time as a consultant of the dealer in the year of 2019.
19.
Yes,
up to,
madam.
up to?
Immediately after up to 2020, the Ford is not available.
No, you work there after, till which date?
Continue at that dealer.
Hmm.
In the last part of that 19, my lord. Because I am lived away because they are not paying my salary.
Last part of the 19 means there must be some date when you left.
Yes,
Because
Lord.
this was, the FIR was filed on 6/12/2019.
Yes, lordship.
When you left?
I am left during the COVID pandemic started 2020, my lord, because in all over around there is no possibility to work any work.
You mean to say that this FIR was filed while you were still in service?
Yes, lordship. And my.
Okay, we need to examine. Then it will be figured.
My lord, let me clear, my lord. In 2019, FIR was lost in 2019, 6th of 12.
6/12/2019.
And in June and later on in the month of December,
Then
I have left the job.
You are named FIR, and if you were there in the station.
Yes.
How it is possible?
And possible is there, my lord. Kindly see in the FIR. They are categorically stated by the informant. They all the money received, which are fraudulently money, all are clear. Because it look after the account. Kindly see the middle part of the FIR, my lord. The company's money received from is kept with the accountant, but how it can in his hand is not known. And how can it possible, my lord? Without my lord, suppose surprisingly somebody booked a car and he gave the 17 lakhs, then how can it possible he gave the personal account? Definitely the GST bill to the deposited the account of the dealer. And my lord, the police also failure to submit the evidence because they are total failure to submitting the charge sheet till now.
Just hold for
Yes, my lord.
the scanned copy of the case diary. Issue notice. Since Miss P. Ginny appear and accept notice on behalf of the state respondent, no formal notice need be issued. Start. List is matter. Again on.
Lordship may fix this matter on 20
On which date?
My lord,
of June,
kindly,
20 of June, your lordship. This Friday.
kindly, my lord.
Interim prayer shall be considered
Fully cooperate with my lord.
on, no?
I am fully cooperate, my lord. Kindly protect me. I am family member.
See, there is confusion. So that is why we'll protect you,
Yes, my lord.
but then let us see the record, okay, once.
Yes.
Please, let us confirm the date and the date of commission of the offense, etc. Because your submission is different and the record it appears.
My submission is
On
clear.
this date, the interim prayer shall be considered.
Yes, sir. Deeply.
20.
20,
28, what day,
26.
what day is?
My
It's a
lord,
Friday.
it may be possible 22nd of. It may be possible 22nd, my lord. Because we come from Guwahati and another matter in pending in
20.
High Court in 20.
22nd is,
Okay.
22nd is
22nd.
Sunday,
22nd, 23rd.
22nd,
23rd.
23rd.
23rd, okay.
Deeply.
Must be blessed. Highly blessed. my lord.
Wait, Lordship. Yeah. Lordship, FIR is at page number 11. The complaint is at page number 14. Married a complaint. Yes. Subject, I, the undersigned, wish to lodge an FIR regarding a serious incident of physical assault causing grievous injuries, criminal intimidation, wrongful restraint, theft and attempted murder that occurred on 23rd of May. The date is very important. 23rd of May 2025 at around 3 p.m. to 4 p.m. at Gompa Road, Itanagar. On the, just a minute, this is against how many people? I'm coming on that. On the said date and time, the accused persons, namely Srimati. Where are you reading? 14, page number 14. Page 14. Yes. Yes. Page number 14, 1, 2, 3, 4, fifth line. On the said date and time, the accused person, namely Srimati Chachi Nablam Lamgu, wife of Sri Denny Lamgu, Srimati Yani Nablam Dada, wife of Engineer Kacha Dada. This is the petitioner. Miss Meming Nablam, daughter of such and such, Srimati such and such, along with 3 unidentified persons, making a total of 7 accused, in a pre-planned and coordinated manner, physically assaulted me using deadly weapons and as such local made knife and dao, thereby chopping off my right ear at Gompa Road, Itanagar. I was surrounded, threatened, and subjected to physical harm without any provocation. The incident was witnessed by Miss Sumita Tok, who can corroborate the facts. After beating me mercilessly, they took my bag and mobile phone. The act has caused not only physical injuries to me, but also mental trauma. The nature of the attack, the number of individuals involved, and the coordination indicate a premeditated criminal act, punishable under the law of the land. I kindly request you to success. Now, Lordship, kindly see the date, 23rd of May 2025. And who I am? I am the husband of accused number 2. Now, kindly come to page number 15. Yeah, how many accused? Total altogether 4. Named accused are 4. Your name is there? No. My wife's name is there as wife of. And you are? Kacha Dada. Wife of, where do I find? Second one, Lordship. Srimati Chachi, Srimati Yani Nablam Dada. Wife of Kacha Dada.
The incident occurred on 23rd of May.
Okay, what is your submission?
Yes, now come to Lordship, page number 15. This is the notice inviting tender,
Page?
15, 1 5. This is the notice inviting tender. And it was to be opened on 22
No,
5.
just, your name is not there.
Not there, mentioned as
Except
wife.
mention
of-
as a wife. of-
Yes.
Okay,
So,
and then how you are accused?
no, I'm
according
not
to you.
accused.
Then
On-
why you are applying this?
Lordship, just because my name is there and my wife and the victim, they are clan sisters. And police are chasing me at SEPA also, here also. I don't know, there is a big apprehension now. Because on 23rd of May, look, page number 16.
Whether any notice or
No,
someone
no
was
notice has
issued?
been given. Just Itanagar police went to SEPA and they were inquiring about me. And then again came at my Itanagar residence and they were inquiring about me.
So
That
what?
is the apprehension.
So what? You are not accused.
I'm
Why
not
you are
accused.
worrying about? Why you are
Because-
running away?
Lordship, here the FIR says 7 unidentified persons. So police are thinking that I was
So
there.
you actually you are in within that 7.
No, I'm not in the 7. That's
Then-
why I am at SEPA on 23rd of May. Clearly indicated. I was opening the tender
That
as
is why I'm
bail.
saying why you are worrying, why you are running away
Because-
unnecessarily. Your name is not there.
Not there because as wife
Your
of
wife is involved. You are not involved.
not involved.
Why should you run?
That is the question arises, Lordship. That is the question.
Police might want to ask you about your wife. Then
Police are chasing me at SEPA also and here also. That's what. That is the only apprehension. Because police might get, they
Then-
might arrest me for any reason.
can that be reason for granting pre-arrest bail to any person who is not an accused person, nowhere connected?
Then why police are inquiring about me at SEPA?
Why you did not tell the police? Why you don't?
Lordship,
Why you did not face the police
That is the question,
to
Lordship.
clarify that I'm not accused. My name is not there. My wife is accused. I'm not accused.
But even
Why didn't you appear
even if
before
I
the
say
police
so,
and say
Lordship,
this?
hypothetically, even if I go to the police station, if I get arrested, 24 hours is gone.
You have a guilty mind.
No, Lordship. I am at SEPA on that very day, opening tender.
So that is why you are showing all this opening tender. So you are not accused.
Not my alibi is very clear. I was in SEPA.
Okay, agreed. So you opening tender, this, you were busy in opening tender,
Yes.
etc. Yes, agreed. Then why you should worry on what I'm saying?
That is the only question I want to ask to the police. But
You ask, go
My-
ask the
my
police.
only
Tell him
apprehension-
why you are chasing me.
Lordship, my only appreciation, if I go there, suppose mistakenly police may arrest me, it will take.
You lodge
24
complaint
hours.
against the police. How can the police
That
arrest
is there.
you
That system
if
is
you are
there.
not the accused person?
Provisions are there, Lordship. Provisions are there. But don't know why, because my wife is involved.
No,
That's why-
where have you stayed? Where have you stated that you have been chased by the police?
Yes,
Police has-
Lordship. Paragraph not 5.
First, you lodged a complaint against the police who chased you for unnecessarily.
Yes, Lordship.
Here, where do we grant bail?
My lord, his
You are not an
vehicle-
accused. Yes.
Your lordship will find in his paragraph 5, he has stated that his vehicle was involved in the commission of the offense on that day. His
Okay.
vehicle.
Okay.
Para 5, your lordship. Paragraph 5, the
Paragraph
petitioner
5.
submitted after registration of the above mentioned FIR dated so and so, till many
You-
days, the name of the petitioner nowhere until,
Landed the vehicle.
yes, the
You
vehicle
used
used by the named
Used in
accused,
Commission of crime.
yes, named accused to reach the place of incident was in the name of the petitioner.
Hmm?
The vehicle which was used by the
Oh.
accused, named accused person is belong to the.
Say that.
He stated in his petition.
The only thing that vehicle was there, but the vehicle was driven by my elder brother.
Where have you stated that? you-
In the paragraph 5 itself.
No. Paragraph 5 is registration of information of prior business.
At page 4. Although the said vehicle is in the name of the petitioner, the same was driven by his elder brother, Sri Tarun Dada.
You could have gone to police and tell the police that
My
My
only
vehicle-
apprehension, Lordship.
your vehicle, if you have not deliberately given for
No,
using.
that vehicle is driven by my
then you
wife
should
only.
Clarify the police.
My wife only. It's for my wife. My other vehicle is with me.
dropped all the accused persons.
Yes.
Yes.
The poll 40 case diary, madam.
Okay. Okay, Mr. K. Saxena, Learned Counsel for the petitioner. This is an application filed under section 482 of the BNSS 2023. Seeking the ground to pre-arrest bail, apprehending his arrest in connection with NDPS case number 88/2025 under section 126 within bracket 2 stroke 118 within bracket 2 of BNS 2023. The case of the petitioner is that the case was registered against three or four accused persons. For under section for commission of offense under section the same 126 to
126 2
118.
and 1182.
2 of BNS. The accused applicant is nowhere connected with the above mentioned police station case. However, due to the use of his vehicle at the time of commission of office from the police is repeatedly. Where have you stated that police is supporting you?
Yes, that is paragraph 6. That the prisoner humbly submits that on the day of incident, that is 23/5/25, there was a paragraph 6
On the day
what
of
is attending a tender opening process in the capital junior engineer.
No. Where have you stated
Here-
that
here
you are
itself.
apprehending your
Here itself, Lordship.
Where?
He even did not know about the such and such, such and such. It is pertinent to mention that when the petitioner was not even in, how can we know? Therefore, the petitioner is reasonable apprehension that he might be arrested by the police at any time in connection with the aforesaid case.
Paragraph 6.
Paragraph last part.
For which the accused, for which the police
And paragraph 3 also, Lords. Paragraph 3 itself.
has been looking for him. Therefore, there is a the petitioner has a reasonable apprehension that he might be arrested by the police in connection with the aforesaid case and cause unnecessary harassment. Okay. Call for the scanned copy of the case title, staff issue notice. Since Mr. Ete appeared and accepted notice on behalf of the state, no notice required to be issued, staff. List this matter again on
19th, my lord. Lordship,
19.
some interim protection.
Till then, it is provided that in the event of the accused applicant is being arrested in connection with the
Itanagar PS 88.
NDPS case number
88.
2025 under section 126 to 1182 BNS 2023, he shall be released on interim anticipatory bail on execution of a bail bond of rupees 25,000, which one surety of like amount to the satisfaction of the arresting authority, with a further condition that the accused applicant shall cooperate and appear before the eye of the case as in, when required, that he shall not hamper or tamper with the evidence of the case in any manner. List this matter again on 18.
19.
19.
Obligation.
Yes.
Lordship, I am impugning the order dated 21/5/2025 passed by Deputy Commissioner C. Yome. Order is at phase number 43. Lordship may kindly note the last sentence of the order. Order phase number
Impugn order.
43.
Yes.
Lordship may kindly see the last bottommost part of the order.
Last paragraph.
Yes, Lordship.
Yes. Okay, you are agreed by this.
Yes, I am agreed by this, Lordship. This
This,
in
it
this
appears
order,
that this was passed on the direction of the, in the light of the. Okay, it's a compliance of the order passed by the court, passed by this court.
yes, Lord.
Petition number 513.
Yes, order is on phase number 38.
So
In compliance of page number 38, this order has been passed by Deputy Commissioner C.
Page?
Page number 38.
38.
Yes. Operative portion is just page number 42. 40.
40.
Yes. Last paragraph.
Just a minute, huh?
Now, Lordship could notice that in imping order, the Deputy Commissioner has used the word amicable.
Just a minute. What
Yes.
is the direction? Let me just see. I thought this is something. Is the direction is only to consider and dispose of.
Yeah, representation dated
Consider and
14/10/2024.
dispose of the representation
Yes,
submitted
sir.
by the petitioner. So. Next one, sir.
Yes, Lordship, I have filed another
Okay.
additional affidavit of that representation.
Okay, you have annexed the representation.
No, Lordship, I have filed additional affidavit.
It was not annexed earlier.
Yes, Lordship, it was not annexed.
So, okay, so direction is to dispose of this representation dated 14/10/2024.
Yes, Lordship.
Okay, so whether it was disposed of by the
Yes, Lordship, the foundational fact of this
Commissioner?
foundational fact of this representation is that the order dated 7/10/1996, judgment dated 7/10/1996 was passed illegally. And to that effect, the
passed by whom?
passed by
In what case?
in the related to the Hayang land case. Now, Lordship, the fact of the case is that
No, when you said
1996, Lordship.
1996.
96, yes.
Okay, the executive magistrate passed order in the capacity of
Executive magistrate past class, Lordship.
executive magistrate in
Yes.
what capacity?
Executive magistrate past class Mechuka, Lordship.
Regarding the land dispute.
Regarding the land dispute. On that,
It was settled by whom?
executive
Only by the executive magistrate.
Yes, Lordship. Judgment was there.
Executive magistrate tried the case.
Yes, that is their contest. That is the case, Lordship. Now that judgment has been challenged by way of filing the appeal before the Deputy Commissioner Alo in the 1996 itself, Lordship.
99, okay.
Yes, and as per their representation, the appeal is still pending before the Deputy Commissioner Alo. Now that the appeal was
Since 96.
96, Lordship.
Okay.
And that judgment is not being interpreted by any judicial order till that, Lordship. Now the land in question is under possession of the
Which judgment is not interfered?
7/10/1996, Lordship.
The executive
Yes,
magistrate.
it is in my favor, Lordship.
For that, the order passed by the executive magistrate.
Yes.
Is in your favor.
Yes, Lordship.
So they filed appeal.
Appeal against that
Before
order,
the deputy
Lordship.
commissioner.
Yes, Lordship.
And then what about the appeal?
Now-
What is disposed of?
Now that appeal is not being disposed of till that. And
Whether
now,
that has been sent to the judicial.
no, Lordship, that is not referred to the civil court.
Transferred also.
No, Lordship, that is not transferred to the
After the implementation of this,
APCC, Lordship.
not yet transferred.
Not yet transferred. And now their contention,
Lying pending before the deputy commissioner.
yes, Lordship.
Okay.
And their contention is only that the appeal is pending before the Deputy Commissioner. Now that has to be referred to the civil court.
Yes.
But in representation,
In terms of the order.
yes,
Or
Lordship.
the government notification, this is supposed to be transferred.
Yes, Lordship.
Okay.
But that has not been transferred by the
Not yet
Deputy
transferred.
Commissioner.
Why it was not transferred?
Stating that the Deputy Commissioner COME has no jurisdiction over the appeal.
Okay.
To that effect, only the
No jurisdiction.
yes, Lordship.
Then where it was transferred then? When the deputy commissioner. said,
Initially,
I have no jurisdiction.
yes, initially the COME Tato comes under the district of West Siang, Lordship. Now, as well, it was West Siang district. Now, after bifurcation of West Siang district into the COME district, now the appeal is pending before the ADC Mechuka.
Okay.
Now, ADC Mechuka is controlled by the Deputy Commissioner COME Tato.
Hmm.
Now, it is presumed that the COME, Deputy Commissioner Tato has jurisdiction over the appeal pending before the ADC Mechuka. Since the ADC Mechuka comes under the jurisdiction of this Deputy Commissioner.
Whosoever may be, where the case is still pending, it should have been transferred before. the
Yes,
court.
Lordship. That is their contention, Lordship.
That is their contention.
Yes,
What is wrong in it?
but that is not being transferred to the competent civil court, Lord. Still that by conducting
Anyone filed any application requesting the deputy commissioner or the ADC to transfer the case in terms of.
yes, admittedly, Lordship, they have filed the representation before Deputy Commissioner. Here it, the representation itself.
But this
Yes, this is the representation.
This was not yet disposed of.
But this is not yet disposed. But while disposing of this representation, the Deputy Commissioner has exceeded his jurisdiction. On the other hand, Deputy Commissioner is saying that I have no jurisdiction
So he
over.
was directed only to dispose of this, but then instead of that, he has passed this order, impugned order.
Yes, Lordship.
Just let us see it again.
Page number 43. 43.
This is confusing.
Lordship could notice that in the last part, last sentence, the word amicable has been.
Yes,
stated.
that is why he.
How the deputy
he-
commissioner can.
Stay, he can, of course.
Yes.
But till the disposal of the appeal, because appeal is pending before.
Yes, Lordship.
But then he says that till the amicable settlement is creating some.
When the
conflict.
matter is pending before any judicial authority, how this word amicable can be used? That is the only contest.
Now, the representation is still pending. This is suppose, is not also, did not say the representation has been disposed of. As it said, whether by this order, could you
No,
make out
any-
that
yes.
the representation dated 14/10 has been disposed of? Could you make out?
No, Lordship, that is also not been mentioned. Deputy Commissioner categorically stated that I was also present there in the proceeding, Lordship. He has stated that he has no jurisdiction over
No, that is why he could have transferred. If he says that he has no jurisdiction,
yes,
he should immediately transfer
exactly,
this
Lordship.
before the civil judge or the district judge.
Yes, in terms of
the
efficiency section 15. Lordship.
Consent jurisdiction.
Yes,
But this order a little bit confusion. What do you say?
My lord,
It appears.
my learned friend is trying to confuse this honorable court, my lord. The writ petition has been filed basically on two grounds, my lord.
Okay.
First, my lord, before that, my lord, kindly come to my lord, the order for which we have
Just a
filed
minute,
the
whether this petition after direction has it been disposed of?
writ petition, no, my lord.
It's still pending.
Yes, my lord.
Okay, then.
My lord, the writ petition was basically filed saying that, my lord, in terms of the, my lord, the public notice, my lord, dated 8/10/2024, my lord, page 21. Kindly see, my lord, page 20. Sorry, my lord, not 20, my lord. It's page 27, my lord. My lord, what happened, my lord? In the land acquisition proceeding, my lord,
Yes.
land acquisition notification was issued and section 18 proceeding was also over, my lord. Thereafter, my lord, section 21 notice has been issued. Lord, you will find at page 27, my lord. 8/10/2024, my lord. This is a notice under section 21 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Settlement Act 2023, my lord. Especially we are proceeding before the collector, my lord. The deputy commissioner happens to be the collector, my lord. Basically, he is the collector, my lord.
Yes.
In a land acquisition proceeding, my lord. So a notice has been issued, my lord. Last paragraph, my lord. Last two paragraph, my lord. Whereas under section 21 of the above, my lord, last two
Which one?
paragraph, my lord. Whereas, my
Okay,
lord.
okay.
Whereas under section 21 of the Act of 2013, the government intends to take possession of the land located at Tato Rapu measuring 50 hectares, Tato 1 and 57.2 hectares at Heo, HP, and therefore all the claims to the compensation and rehabilitation and settlements for all the interest in the land has to be submitted to the collector for disposal within 30 days from the date of issue of this notice, my lord. Claim and objection from the landowners, my lord, for finally taking over the land for the company, my lord. Accordingly, my lord, we have filed the, my lord, objection, my lord. It's not a representation, my lord. It's an statutory objection, which was, my lord, initially not annexed in the civil division petition. It was on the court's objection, my lord, they have filed the additional affidavit. Lords will find in additional affidavit, page 53, my lord. It is not a representation, my lord. It's basically it's a statutory objection, my lord, to the deputy commissioner Tato Sassan. Claim and objection against the acquisition of Hayang land. We are concerned with Hayang land, my lord, measuring about such and such square meter described in the serial number 1 of the annexer schedule of the properties in the notification being proceeded in the name of Sri Tachuk Rinya. My land has been, my lord, proceeded in their favor, my lord. and others were situated at the Tato headquarters for purpose of the construction of the hydroelectric power project. And this is the application. We have submitted the gist of the case, my lord, in this objection there, my lord. The land by an order of the executive magistrate, my lord, the land was, my lord, was given in the favor of, my lord, the civil division petitioners, my lord, by an executive magistrate, my lord, which doesn't have the jurisdiction to decide, my lord, civil matter, my lord. So we filed an appeal, my lord. Appeal was pending, my lord. That's why we have requested that, my lord, not to proceed further with the, my lord, the land acquisition proceeding in respect of the
decision of the appeal.
yes, my lord. We have made that application to the, my lord, objection to the collector, my lord, basically in a land acquisition proceeding, my lord.
Okay.
And accordingly, my lord, that was not disposed of. So we have approached this honorable court, my lord. This honorable court has categorically, my lord, given the direction, my lord, to dispose of this objection.
Yes.
By the, my lord, collector, my lord.
Yes.
So collector has, my lord, decided the issue, my lord, taken up the, my lord, issue, my lord, and, my lord, by the, my lord, impugn order, has said that, my lord, he has no authority, my collector has no authority to, my lord, relegate back to the, my lord, district courts, my lord, under the civil court act, my lord. It is
to the appeal.
Appeal, my lord. Is the deputy commissioner he can do, my lord, but in a land acquisition proceeding, my lord, he is a collector, my lord. Collector doesn't have the jurisdiction to relegate the matter.
No, but in the appeal is pending before whom?
Deputy commissioner, my lord.
Yes, the deputy commissioner can transfer.
Yes, he can transfer in another proceeding, my lord, under the civil court act, my lord.
Yes.
He can very well, my
Yes,
lord.
not as a collector. Not as a collector, but then since the appeal was filed before the deputy commissioner, the deputy commissioner has power and authority to transfer it.
That should be in another proceeding, my lord, not in the land acquisition proceeding, my lord. My lord,
this proceeding, the decision by the executive magistrate was also in the
not in a land acquisition proceeding, my lord.
Okay, so
land
that is
acquisition
why
notification was issued only in the 2023, my lord. The land dispute was, my lord, decided by executive magistrate in the year 1996.
But then appeal was still pending.
Appeal is still pending, my
So
lord.
the appeal is pending before the appeal was pending before, or appeal is pending before the deputy commissioner only.
Yes, my lord.
But now since the appeal in the case is pending before the deputy commissioner, and as per the notification and as per the
Civil Court Act, yes, my lord.
it has to be transferred.
Yes, my lord, deputy commissioner in this case, my lord, he has two distinct identity, my lord.
Right.
First is, my lord, he is a,
In this case.
yes, my
No,
lord.
in the appeal, he is a deputy commissioner only, not as a
Exactly,
collector.
my lord. In a appeal, my lord, he is the deputy commissioner.
Yes.
Under the Civil Court Act, his duty is to, my lord,
Transfer.
transfer back the matter to the appropriate forum.
Yes.
Either junior division or senior division.
No, directly to the district,
Civil
you will
court.
endorse.
My lord, in the civil court, my lord. That one aspect of the role of the deputy.
Right.
Herein, my lord, is the proceeding under, my lord, Land Acquisition Act of 2013, my lord. Notice was issued, section 21, notice was issued under the.
No, there is a separate proceeding. Is there separate proceeding or the appeal?
There should be a separate proceeding.
Should have been. But then let us confine to appeal for the time being. Confine to the appeal. Appeal is otherwise pending before the deputy commissioner only,
Yes, yes,
not
exactly.
for the collector.
Yes, my lord.
Appeal, had the appeal not pending before this, then you see the another proceeding in connection with the land acquisition would have been, of course, under the proceeding under the different proceeding before the collector. But since this is appeal, this appeal should have been immediately transferred.
Yes.
To the appropriate forum.
Yes.
By the deputy commissioner.
My
But
lord,
then you see.
that's why, my lord, that writ petition is still pending in this court, my lord.
Yes.
In that writ petition, there are two prayers, my lord. First prayer is, my lord.
I think there are some more prayer.
No, here not in this.
Four prayer.
That writ petition, my lord.
Okay. Another writ petition, not this one.
No, this is a civil division petition, my lord.
No.
Writ
What I'm
petition
talking
number
about,
513.
this is the writ petition 513.
Yes.
In the 513, you have a four prayer.
Missing prayer.
Page 36.
Yes, my lord.
Yes, here you have a four prayer, but then in the meantime, directed to dispose of the this claimant objection. Okay, this claimant objection, according to you, is not in appeal.
Yes, not in the appeal, my lord. It's a specific, my lord.
Then why it was prayed?
My
Is
lord,
there any prayer for disposing of this? This appears to be specific on the claimant objection in the lane,
yes.
not in the appeal. Is it in the appeal?
No, in the claimant objection under section 21,
Hmm.
we have filed a claimant objection, my lord.
This is not connected to the appeal.
No, my lord.
How it has been then got mixed up?
Because, my lord, the writ petition, my lord,
Hmm.
which we have filed.
This writ petition 513 was filed by you.
Yes.
Okay.
There are two, basically there are two prayers, my lord.
Okay, no, let us see the prayer for setting aside the impugn order, impugn public notice. Just see 39. Ex parte judgment also, and then for direction to the collector, you have made a prayer to a direction to the collector, lane acquisition authority.
Yes, my lord.
For acquisition of lane measuring so and so. To come back to 39, this is your order in your writ petition.
Yes. My lord, page 39, my lord.
Yes.
My lord, kindly appreciate, my lord. Prayer 1.
Yes.
Prayer 1 is, my lord.
Hmm.
For setting aside impure public notice such as issued by Deputy Commissioner COME District under section 21 of the right to fair. Wherein the land belongs to the petitioner's ancestral land has been notified in the name of private respondent in respect of Hayang land, my lord. The in-date notification, my lord, the land was reflected in their name, my lord. That's why we have sought a set aside of that, my lord, portion, my lord. Second, my lord, for setting aside impugn expertise judgment, this is, my lord, two aspects, my lord. This is to be exercised by the Deputy Commissioner, my lord, not by the collector, my lord. And, my lord, 3, my lord, for a direction to collector land acquisition authority for acquisition of the land measuring 50 hectares, such and such, for Heo located at Taifa and Rafum Circle, to pass an award under section 23 of the Right to Fair Compensation and Transparency Act, reorganization and disburse the compensation amount in respect of the disputed land measuring to the respondents, my lord. Not to, my lord, not to this, and accordingly, my lord, for another set of the prayer is, my lord, for forwarding the appeal dated 20/11/1996, which is pending before Deputy Commissioner Tato District Arunachal to competent court having jurisdiction and trial in this process, my lord.
Okay, they are separate prayer.
Separate prayers, my lord, to the director. One prayer, set of prayer is for the DC who is acting under the Civil Court Act, my lord. And another prayer is the DC who is a collector under the land acquisition proceeding under a Act of 2013, my lord.
Okay, so mixed up.
Yes, these are mixed up, my lord. In the
mixed up. That is why.
That is why. So my lord, application objection which we have filed is, my lord, 14/10/2024. And the court has directed, my lord, last paragraph, page 40, my lord. Further, considering the submission made by the learned counsel for the.
But there was no prayer for this.
My lord?
Whether any prayer for this also? 14.
No, my lord. In the main petition we have to see, my lord. But anyway,
Because
my
in the
lord.
prayer this whether it's 4, because this forwarding the appeal, and then not 4 in the prayer it is not there.
Not to 4 is for a direction, my lord, not to, my lord. Disperse the, my lord, not to pass any order and award under section 23, my lord.
Which one?
Prayer 3, my lord. Because if the award is to be passed, my lord, then it has to be passed in the name of the, my lord, the civil division petitioner, my lord, and the respondents in the writ petition, my lord. That's why by the notice, my lord.
Okay, because the land dispute is altogether different
Yeah, different.
and the acquisition is different.
Different, my lord.
So this should have been, the direction should have been.
Two directions, my lord.
To dispose of the appeal.
Appeal.
Hmm.
And also.
And also to dispose of this representation.
Objection, my lord.
Objection.
Yes, my lord.
That is separate. Objection
Separate.
is to be disposed of by the
Collector.
and then the appeal is to be disposed of by this
Yes,
deputy
yes,
commissioner, although the same person,
Same
but in a
person.
different
Yes,
capacity.
exactly.
Should have been, of course.
Yes, my lord.
But then mixed up by.
Yes,
Yes.
my lord, in this case, the entire fact cropped out from the order of judgment dated 7/10/1996. Lord. Now that judgment confers me the right over the Hayang land. Now, as per that judgment only, under section 19 of Lara Act, the award, and section 21 and section 23 and up to section 37, my right has been protected. And accordingly, the award has been passed under section 37(2) of the Act. Now, question is that when all those sections was in compliance with the order that the judgment dated 1996, the question of not passing the award in favor of me doesn't arise, Lordship, unless that judgment is interfered by any judicial order, Lordship.
That 96 judgment.
Because land is under my possession only, Lordship, as per judgment dated 1996.
Unless the 1996 award or the judgment of 1996 passed by the executive magistrate in his favor, unless that is stayed, and probably he has.
No. In this, my legal submission.
Is there any stay into the in the appeal?
No,
whether
no.
that order has been stayed?
Appeal has
Operation
not
of the
been,
order?
no stay there.
No stay.
It was not taken up till date, my lord.
Okay.
Anyway, my lord, legal submission will be there. When my lord, order is being passed in nullity, the court having no jurisdiction, passes an order, my lord. Admittedly, my lord, executive magistrate doesn't have the jurisdiction to settle a title dispute, my lord. So, my lord, it's a nullity, my lord. Nullity can be raised at any point of time, my lord.
No, can be raised at any point of time, but then in the meantime, it has to stay.
No, not
Unless there is a
necessarily, my
stay, unless there is a stay, then if
lord. To
anything.
my respectful submission, my lord. Stay is also not necessary, my lord. If I can prove that,
Then
my lord,
how do one knows or one understand that there is a nullity? The order
then
is
we can make this submission, my lord, to any forum, my lord. Now he is, my lord, seeking, my lord. It's a legal submission from my side, my lord. And if he is seeking any benefit from that nullity order, my lord, then I can also, my lord, apprise my lord, any other forum also from which he is seeking the benefit, my lord. And he cannot get that benefit, my lord. If I prove that the order passed by the court is in nullity, my lord.
Now, just a minute, sir. So this is the 96 decision is with regards to the lane.
Yes, this land only, Lordship.
And by this 96 decision, the lane is decided in your favor.
Yes, Lordship.
So whether this lane is under your possession?
Yes, Lordship. As per 96 order only, the acquiring authority has acquired the land, Lordship.
This is what I propose, my lord.
And that order has been put to challenge by the.
What I propose, my lord, before Lordship, my lord, the writ petition which is pending before this honorable court for a second direction to, my lord, dispose of the appeal by the deputy commissioner, that writ petition will be taken up together, my lord, in next week, my lord.
That writ petition need to be taken up actually.
Yes, my lord.
Lordship may kindly appreciate.
This will have to be clarified in the writ petition.
Yes.
Probably you may, of course, say, of course, he may also say that the learned deputy commissioner has exceeded his jurisdiction. This is in the capacity of this deputy commissioner.
No, as a collector, my lord.
As a collector has.
That is not
exceeded.
also, Lordship, clear in his order,
Exceeded.
Lordship.
It appears.
There is no any provision.
It appears. Where is the impugn order 43?
And Lordship, to my humble understanding, there is no any other provision.
Deputy commissioner.
Yes, deputy commissioner only.
This is deputy commissioner.
The deputy commissioner is the, my lord, name, my lord.
And the deputy commissioner cannot deal with this, the application for claim and objection, isn't it? Cannot.
No, no, but what I am submitting is the same deputy commissioner, my lord, he has two entity, my lord.
That is why he has
That's
to
why, my
clarify
lord, the
that
first
under
line,
what
kindly see,
capacity.
my lord, the first line, pursuant of the Honorable Guwahati High Court Permanent Bench Order dated 11/11/2024, passing 35313, the matter heard to dispose of the instant petition of dated 14/10/2020. 14/10 is what, my lord? 14/10 is a, my lord, objection pursuant to a, my lord, notice issued under the Right to Fair Act 2000.
But then the direction was only 20, I think, 2011. Sorry, your prayer. And the direction was, the direction is 1411, 1410, of course. 1410. But then your prayer is 2011. Anywhere you made a prayer for disposing of the 1411, the 1410,
That's why, my lord, it will be clear from the, my lord, writ petition.
writ petition only.
So, my lord, may I pray that, my lord, the writ petition and this civil division petition may be heard together in next week, my lord.
Okay.
And
so-
my lord, further, my lord,
Lordship.
I seek your lordship indulgence, my lord. The award which he has annexed in the civil division petition, my lord, is very disturbing, my lord. Because as of date, my lord, I have the instruction from the, my lord, my clients who has visited the office of the collector. They said that they have not passed the award in respect of this disputed land, my lord. It's in the, still in the file, my lord. How they have, my lord, annexed in the civil division petition, my lord. No award has been passed, my lord, till date in respect of the disputed land, my lord.
Now,
Now, we have also made complaint before the, my lord, deputy commissioner also, my lord.
Lordship, if we
When
go
the
deep
posting
into,
is state, my lord,
Okay. So
let, my lord, the government advocate take instruction, my lord, whether the award in respect of this land has been passed or not, my lord.
Lordship, page 35. It's
That's
very
why-
clear that the award has been signed by the district collector itself.
Hmm.
And now, Lordship, if we go deep inside to this aspect, there are so many anomalies, irregularities.
No, this
That
can
is
be
other
clarified
aspect which I
because-
don't want to make
because the
submission before
subject
this
matter is
honorable court.
different. The land case, the appeal is different, and then the objection and the acquisition case is different.
Yes, my lord.
So this is to be separated.
Lordship, but 2013 Act does not confer any provision, any power to district collector to suspend the award after reaching up to the section 37.
But this order 21.5 is really a confusion.
That's why,
He
let
had
them take
mixed
the
up-
instruction,
mixed
my
up. You
lord.
take instruction, you just read this order again, and then just see, this has mixed up both in the same, and instead of, and then now the deputy commissioner also, of course, obtain instruction that whether he is taking any steps to forward or transfer the appeal to the appropriate forum. Appeal, why he is not yet sending this appeal before the appropriate forum, in despite of the act being passed.
Even in 1996 judgment, Lordship, these two pro forma respondent is not a party at all. But they have approached before this honorable court by way of filing writ petition in merely filing the representation before deputy commissioner, and that on the strength of that representation only they have approached before this honorable.
Okay.
They are not at all party to the judgment dated 7/10/1996.
Okay, hire Mr. Aringo, land counsel for the petitioner. Also hire Mr. Rintu Saikya, land counsel appearing on behalf of the respondent.
2 and 3, my lord.
You are respondent?
2 and 3, my lord.
Okay, then Loy for respondent number?
Waireram.
Hmm?
Waireram.
Sorry, Riram, Mr. Riram.
For 1 year.
Just a minute, okay. For respondent number 1 and Mr. Rintu Saikya, for respondent number 2 and 3, huh? Okay. You have received the copy of the additional affidavit, sir?
Yes, my lord.
On the prayer of both the parties, let this matter be listed along with Writ petition. C, writ petition C. 513/2024. When?
Fix that maybe.
Writ petition, then it will be listed probably before the vote number 1.
Lordship may kindly make an observation with regard to the page number 35 of this.
Hmm?
Whether Deputy Commissioner has issued this award letter on.
Page 35.
Page
What is
35.
that?
Award.
The award.
Copy of-
Individual awards.
Okay. Deputy Commissioner. What is your question? Huh?
Yes, this may be kindly taken into the consideration when, in this order. Whether this award has been passed by the Deputy Commissioner or not. That observation may kindly be made.
No, wait, not that.
No, no,
matter.
no.
The Lordship, since he has taken,
No.
taken the issue, raised the issue
No,
before this honorable court, Lordship.
Whether award in respect of that higher land has passed or not, that is the question, madam.
No, so let us get it listed along with the writ petition.
Otherwise,
Right,
Lordship may
right,
Lordship may kindly state this, the interim order, Lordship.
Any effective order.
And Lordship may direct the Deputy Commissioner not to proceed with the section 38 of the Act. Since I have not been paid any my compensation amount, so Deputy Commissioner cannot mitigate my land to the proponent. So that may be Lordship kindly.
Get it listed first. Okay?
Because they are proceeded with section 38, Lordship. But it is under dispute, so section 38 cannot be invoked in my case, Lordship. So
No,
that
so,
observation
no,
be kindly.
Government advocate will obtain instructions in this regard also. Okay, and specifically, the sooner the better if the appeal is transferred to the appropriate forum.
Yes.
Okay,
Yes.
then it will be automatically separated.
Settled, madam.
Just instruct them to transfer it.
Yes, yes.
Nothing prevent them to transfer the
Yes,
appeal
in
in
the
the
course.
during the pendency of this case also, huh?
Yes, yes.
Okay. What I said,
Lord,
as requested, let this matter be listed along with the WBC, huh? So and so. When?
no,
After 2 weeks. yes.
Lordship may kindly direct Deputy Commissioner not to proceed with the section 38, Lordship. Otherwise, they will.
Amount to passing an interim order.
Yes, Lord.
After 2 weeks.
Fix that may be given, maybe, Lordship. Fix that. Otherwise, my land are being
No, see,
taken away without being paid, Lordship.
this was filed in the 3/6. Any order passed in the earlier occasion?
No, no, my lord. Because of that incomplete document, my lord, the
Okay.
honorable
Okay.
court was almost about to dismiss the requisition for not
Okay, just a
annexing
minute,
that.
So your prayer, what is your prayer, you say?
Section 38 of the Act, 2013 Act, shall not be given bearing effect, Lordship. Deputy Commissioner shall not pass any mutations of my
No.
land.
So this.
Because, Lordship,
where-
my section 37 has been completed, Lordship. After section 37, not section 30 will come into
No, no.
force, Lordship.
That's why we are raising a question, my lord, whether award has been passed or not. If no award has been
Now,
passed.
this
my lord,
order will
question
not
of section
prejudice
38
both of the party, Lordship. Even if this honorable court reference Deputy Commissioner to proceed with the section 38, that would not
Where is
cause
your
any
prayer? Where
prejudice.
is your prayer?
Lordship, I have made a prayer.
No, my lord, kindly bear for a moment, my lord. When I am saying that, my lord, the award has not been passed, my lord, under section 37, my lord. So, my lord, question. of my lord-
Notice was issued.
question-
No, Lordship, page number 35 is very clear, Lordship.
That's why I am saying that, my lord, the notice which he has annexed, my lord, it was not officially issued by the office of the collector, my lord. How they have, my lord, annexed here in the civil division petition, my lord. That's why, my lord, instruction is needed, my lord.
You
Whether-
obtain instruction in this regard also then?
Yes.
No, okay.
For this reason
Because
only, Lordship,
there
I
are
have prayed,
confusion
I am praying for making observation in this aspect, Lordship.
That's why, my lord, I am submitting. If no award has been passed, my lord, section 38 cannot be proceeded with, my lord.
then acquisition process is suspended and kept abeyance by the deputy commissioner.
Yes, Lordship.
So this will operate.
Operate, my lord, yes, my lord.
Okay.
Operate.
Lord, fix that.
After 2 weeks.
After 2 weeks, yes, sir.
Okay.
Deployment.
Yes.
My lord, I'm praying for an adjournment, my lord, on behalf of SH Sikdar, my lord. I'm praying for an adjournment, my lord.
Pray for adjournment.
Yes, my lord.
Any order pass? Are there? No.
No, no, anyone.
Taking adjournment.
Yes, my lord.
For the petitioner.
Yes, my lord.
What is your name?
My name is not Jama, on behalf of SH Sikdar, my lord.
Okay, Mr.
Timung, my lord.
A.
Timung, my lord.
District Council appearing on behalf of Mr.
SH Sikdar.
S.H. Sikdar. Praise for adjournment of the matter for the bill. Prayer allowed. This is matter after.
My lord, if possible, on 24th, my lord. 24, my lord. 24 minus.
And
24.
I requested, this is matter again on 24 June. June?
Yes, sir.
Okay.
Oh, bless.
24 June. Yes.
Yes, Lordship. Lordship, this is bail application for release of an accused person in connection with LOPS case number 28 of 29 under section 303 clause 2 3172 of BNSS 2023. Lordship.
What is this section?
This is Lordship 3032 is tapped.
Tapped. Okay.
Punishment for 1 year and up to 5 years. And then 317 is stolen property by using the stolen property. This is 3 years punishment, Lordship. Lordship, accused was arrested on 16/4/2025. Now it's been almost 56 days. He is in custody. Now the fact of this case, may I take you to the FIR, Lordship, page 13, 13. FIR 13, Lordship.
13. Yes.
Yes, type copy. Respected Sir, I, Sri Sukhar Ali, son of late Rahman Ali, a resident of Gandhinagar, Silafatar. I am writing this to lodge an FIR complaint regarding the theft of my motorbike. Details of the incident. On 14th April 2025, at around 2:30 p.m., my motor vehicle bearing registration number so-and-so, Mahindra Bolero pickup, was stolen from the vicinity of our house, Along. I had forked the vehicle, and when I returned, I found it missing. I searched the vehicle at nearby area but could not find it. Later on, two thieves, namely Usman Ali, son of Abdul Kalam Narayanpur, Thotburi, POPS Narayanpur district, North Lakhimpur, along with my stolen Usman Ali, so-and-so, and Rafiq Ali. The present bail application is in respect of Rafiq Ali, Lordship. Of so-and-so address, along with my stolen vehicle, were apprehended by CC Borgaon Police Check Post under Silapatar Police Station, District Dhemaji at around 11 p.m. on 14. So you are requested to take necessary so and so. From by this FIR, Lordship, it was intimated that on 14 morning at around 2:30 p.m. his vehicle was stolen. Then on the same day at around evening at around 11 p.m. the Silapatar police intercepted and vehicle was recovered. And from that day, the accused has been languishing in custody, Your Honor. Now, the brief fact behind this case is, Your Honor, the present accused, Rafiq Ali, is professionally a driver, Lordship, daily wages driver. Here also in this case also, Lordship, the one main accused, co-accused Sri Usman Ali, he engaged this present accused person to drive his vehicle to lift a watermelon from the Silapatar market so that they can sell it to the Alo town, Lordship. For that, he has been paid 2,000 for 2 days because one day they're coming down to Silapatar and then on very next day with loaded melon, they had to return back to Alo. So it will take 2 days. Accordingly, this accused, main accused Usman Ali, paid him 2,000 rupees and with a car key, vehicle key, directed him to go with him at Silapatar Lodge. This was only my case, my involvement, Your Honor. I was being paid 2,000 rupees for 2 days. Then since after my arrest, Lordship, initially, Lordship, I have moved a bail application before the learned court, trial court. But since from the very inception, the IO was on leave. On 2 occasions, case was fixed for hearing, call for the CD. But CD was not produced, saying that IO was on leave. Thereafter, without going into the CD, my bail application was rejected on the insist of the council. Because of the on leave of the IO, the accused CD cannot be produced and that process cannot be waived by the court. And on that submission, my bail application was rejected. Now again, Lordship, this bail application was filed on 27/5/25 and it was fixed on 4/6/2025, call for the CD. But again, same story, IO was on leave, CD was not produced. And accordingly, again today, on this date, the matter was fixed and called for the CD. Lordship, till today, it's been
we didn't receive CD. We received WT message from the IO that he is on leave, Lordship.
This is
For medical treatment to his wife, Lordship.
This is the case here.
Now, the IO himself is the OC. No.
Yes, Lordship.
Himself is OC.
Yes, Lordship.
Must be some in charge.
Yes, definitely, Lordship.
Now you see, that cannot be. This probably this bail application before the trial court on 22/5/25 also disposed of. CD is not produced.
Yes.
CD not produced. But then you see the bail was rejected.
Yes, this is the
That cannot be. So we need to peruse the case diary. So you obtain instruction and then.
But the trial court, Lordship, reject on the instance of the applicant, Lordship.
What?
May I take to the page number 23, Lordship?
No, this is the petitioner. This is
Instant-
petition.
They didn't wait for CD. On Lordship, may I take you the bail hearing dated 22/5/2025, Lordship. The operating portion is at Lordship 23. The first para, learned counsel for the appellant had submitted that his bail petition may be rejected if the court consider it fit and proper.
Okay.
The hearing of the bail petition cannot be deferred until the RO is in his duty. Hence,
He wants rejection.
yes, Lordship.
But then once desperately wanted the bail
Yes,
application
Exactly.
is disposed of
I
by
cannot-
rejection.
I cannot
By
keep
rejection.
the custody
No,
independent.
Anyway, we'll not,
I leave it
not
to
go into
Lordship.
that. So
Lordship.
you just
Lord-
obtain instruction and ask them to send a scanned copy of the case diary even if the IO is not present. The in charge of the OC,
Yes.
must have endorsed somebody because it is still under investigation stage.
Yes.
So must have endorsed somebody when the one IO is on long leave, they
Yes.
used to engage. they used to endorse some other person, okay? Yes, because you cannot,
Yes, Lord.
there's a limitation.
Yes.
Yes.
60
I
days,
understand, Lordship.
90 days, there's a
Yes,
case maybe, okay? So, when can you get?
Lordship, before that, Lordship, I have only 4 days to become my mandatory periods.
Okay.
Because the offense, if convicted,
Ah.
it would be, it is 5 years. So mandatory period would be 60 days.
Ah.
Now today is 56 days.
Ah.
For the want of CD only, Lordship,
Ah.
I have been put behind the bar. So this is the conduct. Even my respectful submission would be without.
Friday?
Can it be tomorrow, Lordship? Only to obtain
Day after tomorrow? Hmm?
Okay,
Friday.
Friday. On that day, Lordship, that small observation may be made.
You
If they fail to produce the
Yes.
CD, it shows they have no any intention to contest the case, and they.
Now, you may, you can also pray to reject the bail.
Yes, Lord.
Definitely, Lordship, on Friday, if CD not produced, I have to withdraw. Otherwise, I could not, during pendency of this bail application, I cannot
Right,
book
right, right.
mandatory bail. That's the opportunity. On that day, my bail would be considered.
Mr. D. Lloyd, Dana PP. Some mistakes. The, is the IO of the case is reported to have reported to be on leave, due to which the scanned copy of the case study could not be produced. So the PP is directed to produce the scanned copy of the, so the PP is directed to obtain necessary instruction and directed to produce the scanned copy of the case study of which PS case?
Allo PS case, Lord. Allo PS case number 28 of 2000.
Allo PS case number 28/2025 by Friday. Along with the status report. Okay. Mr. Sorry. Lord and Land Council for the petitioner is also present. Staff, list it matter again on Friday. Oh.
Yep.
May I please, Lordship?
Yeah.
Lordship, this bail application is connected with the Bandadua PS case. So Lordship, may I kindly come to page number 13, Lordship. This is the copy of the FIR, Lordship. So may I read the FIR, Lordship?
Yeah.
FIR against one Pasang Nia, Lordship. With due respect, I have to inform you that today, that on 2/3/2025, at around 6:30 PM, one person, namely Pasang Nia, arrived at our fish shop located at Bandardua Market area.
Okay, when he was arrested?
Lordship, actually, this date is wrongly written. Otherwise, the incident was happened on 2/4/24.
Now, when he was arrested?
Lordship, on
Second
April 25, Lordship.
On the same day?
Yes, same day, very same day, Lordship. Lordship,
how long he have been inside?
Lordship, as of now today, he's 59 days. In the meantime, Lordship, charge sheet is already filed.
Oh, charge sheet already filed?
Already filed, Lordship.
Trial begun?
Yes, at the stage of
Yes, trial
CC.
commenced, Lordship. CC is fixed on 26th of this month, Lordship.
26th of this month?
Yes.
So, so he may be approach the trial court, Lordship.
The court you have produced?
Yes.
Okay.
TCR is there, Lordship.
So what is your submission?
Since trial has already commenced, Lordship, so petitioner may approach the trial court, Lordship.
Petitioner?
The applicant may approach the trial court for consideration of his bail application, Lordship.
Have you approached earlier?
Yes, Lordship. On 2 occasions already, my bail application was
Rejected.
rejected. Lordship, as per the charge sheet, if I am not wrong, there are 14 prosecution witness, Lordship, including 3 seizure witness, Lordship. So it is most likely that trial will take a long time, Lordship. So I may be allowed to go on bail and to face the trial from outside, Lordship. The applicant is lordship, my younger brother, who is a government servant. And the eligible person is also a permanent resident of Bandadua.
But the trial court indicated that he's nuisance and threat to the society
Yes, exactly.
Lordship,
Lordship.
that-
while rejecting the bail.
Lordship, I am 58 years old. I have no any criminal antecedents till now.
So now you will start, you
No,
will,
no, Lordship, Lordship, that
you
was,
think that now
very
it's
un-
time to start with.
No, Lordship.
The offense he committed.
It is in the open,
Lordship,
it is in a
Serious
in a
lordship.
open market
Without any provocation.
without any provocation.
Lordship, if I am guilty, Lordship, I will be punished after the trial. Lordship, at least I may be allowed to defend myself.
Prima facie, it is clear, it appears.
So I may
Of
be
course,
allowed.
though, we cannot come into that conclusion, but then, see, admittedly, it was in the, it's open in the market itself.
Of course,
That's
Lordship,
problem.
the allegation
then
is serious, Lordship, at least.
Hmm?
Of course, Lordship, the allegation is serious, but Lordship, I may be able to go on bail with any terms and condition, Lordship. There is no chance of availing the trial, Lordship. I am resident of, permanent resident of Bandadua, Lordship. And the bail applicant is also, my younger brother, who is a government servant, Lordship.
Applicant, we are not, we
Yes,
don't have
boss.
any grievance with the, probably you should not have any grievance against the applicant, but then with the accused.
Lordship, there are,
So
Lordship, there are 14 prosecution witnesses. Lordship, it will take less
maybe,
than 2
maybe more than that also, because
Yes,
it was in the open market.
Even if he was
The
released on
incident
bail.
took place in the open
There is
market.
chances of
What is
referring-
the, what is the provision, just a minute, huh? The offense charge sheeted, section is
118 close to Lordship BNS.
one
Voluntary-
182,
Yes, Lordship. Voluntarily causing grievous.
not
hurt.
the attempt.
Not Lordship.
It was in the vital, you see, vital.
Yes.
So according to IO, it was not an attempt.
In fact, Lordship, to my humble understanding, intention was not there, Lordship.
Okay, so bail to be granted.
No, 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 I'm not on that. 3037 was not there, that's why. So.
Hmm?
Attempt was not there, that's why. Lordship.
307 is not there.
Yes, maybe, Lordship.
He went back, brought the sharp weapon.
That's why
Check.
I was
Not
not
only one
concerned.
person, 2 person. That is also on head.
Yes.
Actually, the accused person was returning from his paddy field. So,
Hmm?
the accused was returning from paddy field. Lordship.
Accused
Was returning from his paddy field, and the machete was in his car only. Lordship. Just due to confrontation only. There was no any intention, but just
So coming from
on the heat of.
Paddy field doesn't acquire any right, give him any right to attack any person.
Lordship, the Lanet PPS rightly submitted. Lordship. There was no any intention. But just Lanet PPS
Okay.
No, no.
clearly submitted.
Maybe, I said maybe. That's why I
When Dana PP submit maybe is it indicate lot.
Yes, Lordship. I'm so sorry.
What is the report? Grievous. Medical report also grievous. Okay, what we'll do? I'll pass order. Yes. Keep this also for some time. I'll pass order. See the record properly and pass order.
Yes,
Okay. I haven't seen the record.
Yes, sir.
See the FIR.
TCR is before your Lordship. TCR is not with us, Lordship, with the court, Lordship. That's why.
Oh, this is with the court only.
This
Okay.
from the trial court
Okay,
only,
no
Lordship.
problem, no problem. I'll pass order. So, let us, I'll pass order today itself. Okay, dispose of.
Obliged.
Deeply obliged.
Even if the bail is granted also, of course, strict condition will be imposed.
My pleasure, Lordship, my lord. Whether am I audible, my lord? My lord, item number 9.
Yes.
May I please, Lordship, my lord?
Oh, that's what. Okay. Just a minute. Huh?
Yes, my lord. May I praise your lordship, my lord?
Yes, please.
My lord, this is an application under section 482, my lord. In connection with my lord, Itanagar case number 72 of 2025. And I am not the name accused person. There is no any allegation against me. Only, my lord, my lord, production report was submitted before the court in connection with other case. Wherein, my lord, there is a reference that one revolver, my lord, firearm was recovered from my residence while I was at Delhi. And that was in silk cover. And our defense case is that, my lord, we have made positive statement in our application, in the bail application, that it's the maternal uncle of my wife, my lord. He was arrested in connection with earlier case, Itanagar case number 6 of 2025.
Yeah.
My lord, on the allegation that he has got connection with, my lord, NSCT, my lord, ban organization. And accordingly, he was arrested. And another person was also apprehended.
Lordship. I flagged the operative person, Lordship.
Okay.
Yes.
So record was called for. Just wait.
Yes. CD was called for. Production report, my lord, only the production report.
When
my
is
lord,
the file
reflected.
filed? Okay.
FIR was filed on 3/5.
Yes.
3/5.
Just a minute. What is there any material against the accused persons?
Yes, there is, Lordship.
So any recovery made from
The son of this applicant, Lordship, handed over the gun to the police station, Lordship. Handed the illegal arm to the police station, Lordship.
Yes.
The accused son, Lordship. The alleged accused son. This applicant's son, Lordship.
Son of the accused.
Son of the accused. Yes. In fact, his name was not in the FIR, Lordship.
So he has not been made as accused.
Yes.
No, he was not made it.
Just a minute. Yeah. Why he deposited the
Lordship
firearms before the police station?
Yes, Lordship. Lordship, may I?
Okay. Yes.
On the basing of FIR, Lordship, the targeted operation was conducted by the police, Lordship. During the operation, they seized some illegal firearm from different places, Lordship. And during the course of investigation, the the applicant's son, on his instruction, father's instruction, Lordship, handed over the arm before the IO, Lordship.
So while he was absconding or he was there?
No, as per their statement, he was absconding, Lord. As per the IO report.
But then instructed.
Not absconding, he was at Delhi. There is no allegation that petitioner, my lord, was absconding. He was not present in the house. He was at Delhi.
While he was absconding, he instructed his son.
Yes.
To
hand over the
arms which were available with him before the police station.
Yes,
in connection with the present case.
Yes, sir.
So what were the arms?
It is not the allegation,
that was seized.
Yes, Lordship. I flagged the second one, Lordship.
Seizure memo.
Yes, seizure memo with the statement of his son, Lordship.
Yes, 54-56.
Second plague, Lordship.
Second plague is the probably this is investigation. This is CD only.
Statement
not
of
marked. Open. Who surrendered? Volunteer Aman Dugi. Aman, who is this?
Aman Dugi is the son of this Lordship.
Aman Dugi himself also surrendered.
Yes, Lordship.
He is also one of the member.
No. He is the son of this present applicant, Lordship.
Okay, why the son has to surrender?
On the instruction of his father, the present applicant.
No, this is not the election contention.
As per
What is the allegation that he, at the instance of, at the instruction of the petitioner, son surrendered? Our whole contention is that police came to our residence, there was a raid, search operation, and ultimately it was police asked them whether there is any revolver. And then they may disclose the fact that the maternal uncle of the wife, he is connected with so he came and he asked us to keep it in your custody. I will take it back.
Now, what is the name of the accused?
Name of the
Accused Karan
accused,
Dugi, Lordship.
Karan Dugi.
Karan Dugi. Karam Dugi.
Whether the Biro Gumja Tamin is also accused.
Yes, Lordship.
He is not in, not.
They are the name. They are the name FIR, Lordship.
Okay.
This Dugi.
But he is not before us today.
Pardon, Lordship?
He is not before us.
No, no.
Okay.
Only Karan Dugi, Lordship. Present applicant, Lordship. After arrest of this Lordship.
Arrest of?
Arrest of this accused Biro Gumja, Lordship. Biro Gumja, Lordship.
The Biro Gumja was arrested?
Yes, Lordship.
Okay.
Basing on the FIR. And on his disclosure, only his information, the targeted operation was carried out, Lordship.
Okay. So there in the operation, whether anything recovered?
Nothing more. This arm only, Lordship. The surrendered one, Lordship.
Lordship, kindly see me at page 56. Production report, my lord. Lordship will be able to understand, my lord, what is the exact allegation. Page 56. 1, 2, 3, 4, 5, 6, 7. My lord, 1, 2, 3, 4, 5 from top. 6 line from top at page 56. Page 56. 56. My lord, 6th line from top.
Yes.
My lord, may I read, my lord? One more
Page
illegal,
56.
page 56, 6th line from top. One more illegal firearm was seized, not surrendered, seized from Amon Duge, son of Karan Duge. There is a petitioner. A said illegal firearm has also been sold to Karan Duge by the accused Amja Tamin. Biro Amja Tamin, a sum of rupees 3 lakhs. My lord, this is the only allegation that it was seized from the son of the petitioner. And at that point in time, petitioner was at Delhi. My lord, kindly look at the background of the petitioner. Petitioner is a, my lord, well-known singer. He is a, my lord, social activist. He executed a number of, my lord, environmental projects. He is connected with NGOs, and he is a renowned singer. That apart, he is a proprietor of a, my lord, consultancy firm. Number of government projects are, my lord, executed by him. The maternal uncle, my lord, who was arrested. One day he came and asked, he is, my lord, nice to keep it in your custody. I will take it back. In the meantime, police came, my lord. On the other days, my lord, when the motion petition was moved, my lord, motion was moved, and my lord was pleased to, my lord, indicate that there is a defense case. Therefore, that defense case may not be ignored. An innocent person who is no way connected to the extremist, my lord, somebody has come and somebody has asked me who is a near relation, my lord. And you keep it in your custody, I will take it back. In the meantime, police came and police recovered it. It is not the correct factual position that, my lord, it was surrendered. The son of the petitioner surrendered. He is a minor son, and he ultimately handed over the gun to the police at police station. This is not the correct factual situation. Because my lord, page 56 is absolutely clear. It was seized from so-and-so. Had I been, my lord, or my lord, been involved, or if I had a bad antecedent, or my lord, some objectionable background, then of course question would not. His social status, I have an ex, my lord, there is a very well-known singer, and he is connected with various social and cultural organizations, and he is a social activist. He implemented various environmental schemes of the government. I've given an elaborate, my lord, statement in my petition. And at that point in time, he was at Delhi. And we made a statement that he was reported by his wife. The police came and ultimately it was, my lord, handed over to police. Innocently, fairly, my lord, honestly, they have disclosed that yes, so-and-so came and so-and-so asked me to keep it with you. And accordingly, my lord, we did not even break open the seal box, my lord. What,
What is this? You
was,
have what is this? You have annexed one, this order. What bail? This is bail. In
this is
respect
in
of,
connection with other case, madam.
so this is in connection with other case, the
Other
same
case.
accused
In that
person.
case, there was an interim bill in our favor. And there is a reflection in the interim bill that he is innocent, he does not have any connection.
This is also similar nature of case.
A similar is okay.
Hmm.
In connection with the same incident, two FIR. And whether I'm involved, or whether I'm not involved, that CD will just reflect.
Just
I cannot just refuse the or dispute the fact
What
that
area? Lordship, this is also the CD, Lordship, but it was not in proper format, Lordship. Just recording of the statement only, Lordship. Same, Lordship.
Same. Why?
Two set, Lordship. But it was statement was the earlier one statement was put in the format, Lordship. But in this, the only record statement was there, Lordship. It was not in the
present. Okay.
statement of other accused person. Now,
Firearms. The present accused is Karam Dugi.
Yes, Lordship. Rating is same, Lordship, just not put in the format of the CD, Lordship.
Illegal firearms and so this Libemo T Kithan is different again.
Yes, Lordship.
Another whether he has been arrested. He's from Nagaland.
number of persons
Yes,
were
Lordship.
arrested.
Hero Gumja not yet arrested.
Biragunja arrested. Also, you'll find it in production report, which shows the Biragunja was arrested.
Okay, the Karam he purchased from Karam Dugi. So Karam Dugi, he is still absconding.
So not purchased.
Sir, Karam Dugi purchased from Biro Gumja, the present accused. He also purchased. And then the surrender one.
Yes. Through his son, Lordship.
Okay.
License. License দিয়ে থাকে।
Anything else? Any comment?
Therefore, the allegation as it reflects, as the Lordship pointed out that it was purchased by foreign Dugemer, but in fact it is not. It was not purchased. We say that he is the maternal uncle, own maternal uncle of the wife of the petitioner. One day he came and he asked my Lord Nice to keep it with you. I will take it back. And that was in the seal cover. We did not even broke open the my Lord seal cover.
What seal cover?
My Lord, what was it kept inside the box, my Lord, that was sealed. We did not, my Lord, break open. Police, my Lord, just took it and my Lord, with them. And we didn't know,
What do you
have
to say
any
that
knowledge,
there-
any
the
knowledge, my Lord, what is
allegation
what
that
in the bag, what was kept inside the my Lord box or bag. We didn't have any knowledge. That was our positive, my Lord, statement we have made in the application. And if somebody says something, my Lord, that is not known to us.
What do you have to say that Biro Gumja or the accused, accused, Biro Gumja
Yes.
has also purchased an arms from you, the present
No.
accused.
No. They are saying that I purchased, the present petitioner purchased the my Lord gun from Biro Gumja. It is the my Lord, as your Lordship pointed out.
Okay, Biro Gumja, sorry.
Yes. And our contention is that he is the own maternal uncle of the wife of the petitioner. And he made a request to keep it with you. And I will one day, someday I will come and take it back. And our contention is that my Lord, it was kept inside the sealed box. And we did not even make an occasion to break open the box. And police came, police took it away. And we have disclosed the fact. And at that point in time, my Lord, petitioner was at Delhi. Since long he has been at Delhi for some contract work, my Lord. And recording powers. He is a very good singer, renowned singer of the state of Arunachal Pradesh. And we have given, my Lord, one annexure pertaining to, my Lord, in support of that contention. Video this, na? And since it was recovered from his possession, of course, my Lord, and whether that fact may be the basis to connect the petitioner with some ban organization. Because the whole allegation is that they are connected with NSCT, NSCT ban organization, and it is reflected in the production report itself that Gumja is connected with ban organization. And my Lord, whether that factual fact is sufficient to connect me with the ban organization. And even assuming that I purchase, my Lord, he is my relation, and I might be said to be a bona fide purchaser. Of course, my Lord, I should not have. Even assuming that I have purchased, he is my relation. If any offer is made, and if I purchase, you know, out of any reason, then I am a bona fide purchaser. In that situation, my Lord, whether I can be said to have connected with the ban organization or involved in, my Lord, other anti-social activities, extremist activities. But at the same time, my Lord, as your Lordship knows, my Lord, Supreme Court says, my Lord, defense case may also be considered. If the defense put on record certain facts in support of the defense, that particular facts may be taken into consideration.
What did you say about the pistol surrendered by your son before the police, saying that it was under your instruction?
Yes.
It was under your instruction?
No, my Lord, this is not, my Lord, we denied that fact. We said that police came and police made a search operation.
Then it will be treated as have been seized from your son, and it was under his possession, not on the instruction of you. He has delivered before the police.
Yes. Police came
So
and
that
police
means
took.
there is, the action of your son is independent of your instruction.
My lord, because I was out of station and my lord, came to know everything from my wife. She reported me that police came, police conducted a search operation and it was recovered. And when police
No.
made a pinpoint query,
No, your son appeared before the police station with the gun, firearms,
well,
firearms.
it is their contention. It is their contention. Our contention that police made a search operation on the basis of some secret, my lord, source of information. Police came, police asked, we have the information, that something is, my lord, some firearm is kept in your custody. If it is so, then return it. Then they disclose the entire fact. What actually happened, my lord, how it has come into their possession. They refer the name of Gumja.
Anything else?
This is the only. And my lord, we are ready to, my lord.
I objected the bail application since it was investigation was in a nutshell stage, Lordship. Bail may be.
Whether, my lord, that particular fact is sufficient to.
Other than this, anywhere else?
Nothing, Lordship.
Name, there are also particulars of validity. Okay.
The other one, no, there is no any allegation.
Who else has revealed, else has taken name of the present accused?
Biru Gumja.
Whether Tapa Numnu has
No.
taken his name?
Yes. Lordship, as per CD,
Give it back. to you. Purchase, whether live rounds also were recovered from the present accused?
Lordship.
Arms,
No,
ammunition, sorry, ammunition?
it was not recovered from my possession.
Lordship, only arms which was handed over by the son only. Lordship.
Okay.
He must have some, my lord, information that police is supposed to made a search of, and then questionably, he will go and hand over the, my lord, our firearms. But the facts remain that police came, police made a search operation, and at that point in time, they disclosed the fact, actually how the firearm came into their possession. Therefore, it is altogether not correct.
Could you please repeat how it came into his possession, firearms?
We said that, yes, paragraph 3 and paragraph 6, we have made a positive statement that Biru Gumja, my lord, Tamin is the maternal uncle of my wife. And he has a frequent visit. And one day he came and he made a request, keep it with you, and I will take it back.
Whether he
Then, my lord, there was a search operation.
whether he is also accused?
No,
Yes,
no.
yes, Biru Gumja.
Biru Gumja isn't accused.
As per their
Is the accused, my lord.
Lordship, Biru Gumja happened to be the maternal uncle of the
Maternal uncle of the wife.
wife.
Old maternal uncle of the wife.
Yes, maternal uncle of the wife, Lordship.
He came and he made a request. And we innocently, my lord, since he is very close.
Let us see the statement of the Biru Gumja Tamin.
Biru Gumja's statement, my lord, we don't know what is, my lord, what he has actually, my lord, stated. Page 56 is the production report. Production report reflects. And production report does not say anything that my lord, Biru Gumja sold the firearm to the petitioner. This is the production report. That production report was submitted before the court in connection with the arrest of Biru Gumja. And that production report does not say anywhere that it was sold by Biru Gumja to the petitioner.
Lordship, statement of Gumja is not with me, Lordship. Biru Gumja.
Biru Gumja's statement is relevant, my lord.
Not in my copy, Lordship.
He was arrested? Was he arrested?
He was arrested. And in connection of his arrest, my lord, production report was submitted before the court at page 56. Lordship, may kindly have a look.
Page 56.
Yes. My lord, it starts from 54. 54. Production of arrested accused, pair for also the headline, my lord, days of police custody. And in that production report, it is reflected that Viru Gumja was arrested. And may I just read, my lord? 3/5/2025 at 1800 hours, a written first information was received from DSP Sanso stating that one accused, namely Viru Gumja, Tamin, who happens to be my maternal uncle of my of the petitioner, resident of Sanso, arrested. He was arrested, madam. Can you see? He was arrested in connection with Itanagar at page 54. At page 54, it appears from the very first paragraph that in connection with the earlier case, my lord, he was arrested. In earlier cases,
the statement of Biro Gumja is also because you said that it is from Biro Gumja. His statement is not
If statement of Gumja is not with my copy, lordship, may I look at lordship?
and it is, my lord, stated in the production report in very first paragraph that Viru Gumja is suspected to have connection with ban organization.
Yeah, that is why.
Therefore, my lord, it is not at all the correct factual position as it reflected in the production report that Viru Gumja sold the firearm to the petitioner. And we don't know, my lord, what is the statement he has made. Is there any statement he made, my lord, that he sold the firearm to the petitioner? And kindly, my lord, on the same very page, the last para, acting on this intelligence, a raid was conducted. Kindly see, the raid was conducted on 2/5 so and recovery one firearm so. And in the last portion of the production report at page 56, my lord, there is a clear, my lord, indication that one more illegal firearm was seized from, my lord, Aman Dugi, son of Karan Dugi. Therefore, it was seized from his possession, my lord. And there was a search operation, as it reflected in the very first page of page 54. On the basis of sources, my lord, some secret information, some search operation was conducted. Ultimately, police came to our residence, and during that operation, my lord,
Lordship,
it was recovered.
So he is important because it is alleged that he kept it.
The statement made by PP, my lord, that it was.
His statement is important. Yes, Lordship.
Yes, his statement is important.
In the afternoon, at 2, 3.
So I will try, Lordship. At 2, Lordship.
My lord, if it is not possible, then lordship may fix the matter tomorrow.
Okay, well, then we will get it listed tomorrow again.
Tomorrow at 2, my lord.
Tomorrow at 2? At 2. Okay.
My lord, lordship, kindly make an observation. They will give the connection, virtual connection.
Tomorrow there will be DB also. So day after tomorrow, in the morning. Day after tomorrow. Tomorrow's case already listed. All this already prepared.
My lord.
So this will be listed day after tomorrow.
Yeah. My lord.
And this probably is not a complete.
Yes, Lordship. Sorry. It's pertaining to that. This Karam Dugi only, Lordship. That's why.
So no, because he is connected.
Yes,
that is why his statement is
necessary, Lordship.
Necessary, and that will clarify whether.
Yes, exactly, my lord. My lordship, right point. May I just make a request, my lord? Can it be a first item, my lord? If your lordship be kind enough.
Yes.
So that we can attend the other court, my lord, at the same time.
Okay. Mr. A.K. Purkashta, Land Counsel for the petitioner. Okay. Mr. Staffer, Mr. D. Lloyd, Land Public Prosecutor. Some stats. The case study produced in the case study produced before the court today is not a complete. Is incomplete, therefore praise for allowing him to produce the complete case study and praise for 1 day time, stop prayer allowed. List this matter on the other tomorrow would be 13, okay.
30 minutes is first item, my lord.
It will be taken up only. This will be taken up only. Automatically it will reach. First
Automatically-
item, probably the motion item will be there.
Oh, yes, yes.
Bail hearing. And this is bail hearing.
My lord.
First item in the bail hearing.
Then
Okay.
lordship, can you take up the matter at 2 then, my lord? 2.
At 2.
At 2.
Okay, then
My lord.
mm,
I don't know, বন্ধ আছে, উঠে যাবো তো।
this is matter again on Thursday, Friday, on that is on date. Okay, at 2 p.m. Okay.
Obligation.
Okay,
Obligation.
2
Obligation. Obligation.
Yes. Yes.
Time for the petitioner, your lordship.
Lordship, here I am for respondent. We have to file our affidavit. However, respondent is living at Gujarat, so we need some more time to file our affidavit.
Okay, Miss
And Honda.
Lani counsel for the petitioner, please. Mr.
Emertha.
Your name reflected here. M.
Emertha.
Lani counsel, appearing on behalf of the respondent number. How many respondents are there? Sole respondent?
Yes.
Okay, the respondents. Some that they need to file affidavit in opposition. They have to pray for which they require needed some time, some more time. So prayer allowed. This matter after 2 weeks. Okay. In the meantime, you file.
Yes.
Give your measure.
Yes.
My lord, this case, as per the conviction order, is 90 of paper book.
Paper book, you have received the paper?
Yes.
Okay. Now,
Now-
it will be listed for hearing. My order.
Yes, your lordship will see the report of the OC in charge, your lordship.
Okay.
Diana, please stay.
Which one? This is order.
No, your lordship. I have just submitted the report, your lordship. The second page is
Okay.
where
Although the office note dated 10/6/2025 reflect that the service reflect that the service report in the of the respondent is yet to receive from the office of the PP, the Miss Jenny additional PP produced a copy of the returning service report from officer in charge police station Mebo, informing that the notice to Sri Nangkong Pangi has duly been served and returned after closing service starting. In view of the above, the notice is complete. However, no one appears on behalf of the respondent number two. Is it? High Court Legal Services Committee is directed to appoint one legal aid counsel from the panel advocate to represent the respondent number two. Okay, so at least this matter again on after 2 weeks, after a week.
And after two
After
weeks.
2 weeks. Okay.
Your Lordship, I have
For
a
hearing, for hearing.
I have a small submission, Your Lordship. I have gone through the paper book, Your Lordship. There are some documents which need to be annexed in the paper book is charge sheet, arrest memo, as well as the seizure.
It's not.
It's not
incorporated.
in the paper book, Your Lordship.
How it is possible that? The trial court record is there, otherwise.
It's there otherwise.
So then the copy is already served. Then it is incomplete.
Yes, Your Lordship.
Then
An additional
since
paper.
the record is also already there, can be taken up for hearing along with the record.
It can be, Your Lordship, but then since the records are always with the courts, under the court, Your Lordship, it becomes difficult for us to peruse the submission, Your Lordship.
Okay, Miss Jenny for the submission. And then I pointed out that although the paper book were furnished to the parties, it does not contain certain documents, including what are those documents?
Your Lordship, charge sheet is there. One arrest memo as well as the seizure, because the age of the victim was also in dispute, Your Lordship. Arrest memo as well as the seizure memo, Your
Arrest
Lordship.
memo, the seizure list, and what else?
This too, Your Lordship.
Seizure list not exhibited.
Not, Your Lordship.
The registry shall do the needful to incorporate the document, the above document in the paper book. Then in that case, it will take a little more time.
Yes.
Informant, stroke victim is still awaited. List is matter after 2 weeks. Okay.
No, Your Lordship, in fact, since the victim has not made a party, Your Lordship, therefore.
We are in 16.
Item number 16. Therefore, direction from this court to take steps upon the victim's
Is
mother.
there any order? Yes.
25/3/25, Your Lordship.
25. This is not a jail appeal.
It's not a jail appeal.
Okay. Then just a minute. One. Mr. Ibam, Lani Counsel for the appellant staff. Also had Ms. Lani additional PP for the state staff para. The victim, the informant stroke victim has not been impleaded by the respondent party.
So this is
The informant stroke victim.
Your Lordship,
is the third party.
Your Lordship, I'll just make small submission, Your Lordship. This is a case under 304, Your Lordship. The deceased mother.
Just a minute. It's not a POXO.
Not.
Then why the victim is to be?
In regard to Jagjit Singh's case, Your Lordship.
Huh?
Jagjit Singh's case, Your Lordship. In terms of
What
Jagjit
it
Singh,
say?
that a person, the victim has to be made a party from the stage of trial as well as in during the stage of appeal as well as in revision petitions, Your Lordship. Participatory right of the implementing.
Okay. What, in view of which case?
Jagjit Singh's case,
Okay,
Your
in
Lordship.
view of, just hard, in view of the decision in Jagjit
Singh case, Your Lordship.
Singh versus,
Have to just look,
You have
I'll
to
just
answer.
inform the citation
give,
along, yes.
now versus so and so, reported in so and so. The victim is to be made, victim.
Slash
victim
info,
is-
informant. Your
304 means victim is no more.
Yes, informant, Your
Victim's
Lordship.
family is to be made as a respondent party. Stop. In view of the above, the appellant shall implead the mother of the victim as the respondent number 2.
Yes, Your Lordship.
In the appeal, act, taking steps upon the, no, here also, but then because it may take longer time, so you have to, in the judgment also, you have to refer that victim, Mr. So and so represent victim or respondent number 2. In this, you have to amend the course. Yes, that is why. Since you are impleading, you have to course title unless amended. So where do we know that there are 2 parties, 2 respondents? Okay. And we have the the appellant shall amend the course title by impleading the mother of the victim as respondent number 2.
Yes, Your
You
Lordship.
see, okay. The appellant has already taken steps upon the mother of the victim. However, the service is still awaited. However, the service report is still awaited. Release this matter after 2 weeks. Okay.
Material.
Yes.
And not the sole respondent, they have not filed any objection as on today. In spite of order passed by this honorable court on last occasion.
Okay.
My lord,
So this is condonation petition.
yes, my lord, condonation petition, my lord. My lord, in fact, on the last occasion, I was not present, my lord.
How many days?
2,555 days.
Almost 7 years, my lord. Otherwise, my lord, normally I would not have objected, my lord. However, my lord,
What is this case about? Otherwise, the case is dispute is about
Land, my lord, land
Land.
dispute.
This will be
they are impugning the judgment of 2017, man.
so revision would be against the order passed by whom?
By the senior division.
Senior division.
Yes.
That is also which I really want to dispute, my lord, whether it will be applicable, whether CRP will be applicable or not, my
So
lord.
how many time you have given an opportunity?
I have given the reasonable grounds why it was delayed.
Only 2 occasions, my lord. In fact, I have submitted my wakalatnama, my lord. Thereafter,
Now,
on the last,
there is objection.
yes, my lord. No, the last occasion, my lord.
Otherwise, you see, it is to be decided on merit.
Yes, yes.
And then
However, my lord,
can be condoned. The delay can be condoned.
my lord, since this is 2,500 days,
700.
almost more than 500 days, my lord. Therefore, my lord, at least I may be given opportunity, my lord, to file my preliminary objections, my lord. And
So last chance will be given.
my lord, my lord.
Last chance can be given.
Already last time was given.
Last chance was given.
Yes, my lord. Last one, but I did not appear on that particular day, my lord. Because I was out of station, my lord.
Mr. Thieson, land counsel for the applicant, stop. You appeared or earlier somebody appeared on your behalf.
My junior associate appeared, my lord.
Land counsel appearing on behalf of the respondent some years later. He was out of the station, due to which he could not file affidavit in opposition. therefore pray for one last chance to file affidavit. Sorry, objection, file objection. Start, ends of justice, for the ends of justice. One last opportunity is granted to the respondent to file objection in the matter within a week from today.
We will be little hurt, my lord. In fact, the argument considers from Guwahati, my lord. Family, at least 2 weeks time may be given, my lord.
Okay.
Huh?
2 weeks.
Okay.
Okay, list is matter. The prayer is allowed. List is matter after 2 weeks.
My lord.
Problem.
Problem.
Petitioner side is absent. Petitioner side is absent today. This is also criminal petition. It's already been
Okay,
charged
you have
with
received the scanned copy.
yes, Lordship, but as per the instruction, Lordship, it has already been charged with it.
Charge sheet.
Yes, Lordship.
So they have challenged the FIR only.
They have challenged the Jimma Lordship, their Jimma Lordship, and at the same time we have called for the scanned copy of the TCR record also.
Jimma application was rejected.
Yes, Lordship. Because the NDPS Lordship, they have vehicle, they have the possession in the still in the court Lordship, so they have to take.
The record was called
Yes,
for that
Lordship.
means.
We have to call for record already called for, but it has not received yet, Lordship.
Okay, you have not received.
TCR record
Okay.
from registry, Lordship, it's
No
called for.
matters on call, on behalf of the petitioner on call. So, however, whereas Ms. Elhage Lanet additional PP is present. Stop, the
Scan copy of TCR may be called for, Lordship.
hmm,
Scan copy of
received
TCR.
from the district. It says scanned copy of trial court record received.
Oh,
from
then
the
it's
district.
okay.
It's there only.
Lordship.
Okay.
Then Lordship, then fix for admission hearing on next date, Lordship.
Petition. The scanned copy of the trial court record has also been received. Stop. In view of the above, list is matter for admission after 2 weeks. Okay.
Right.
List is matter after 2 weeks for admission. Okay. Yes, next.
This case, my lord, has stayed the trial proceeding pending before the Sessions Court, Bomdila. Since the TCR has been received today, my lord. Last order.
Lordship, TCR call for,
Yeah.
Lordship.
This is
my lord, in respect of quashing of the trial proceeding pending before the Chief Judicial.
it's a
Magistrate,
joint petition.
my lord.
What is the offense involved?
Offense is, my lord, 341, 324, 452, 427, and 506.
Which one is not available?
Except 452 and 324 is non-compoundable. Otherwise, other 3 sections are compoundable in nature.
452 and
452 and 324.
what is the stage of the trial?
Well, it was only at the stage of framing of charges, CC. I have enclosed the order.
Hmm?
Page
Enclosed
number
order.
42 of my petition will find my.
Okay, just let us see first the allegation. Okay, what is the allegation?
Allegation, if I may take my lord to page
The
number
situation,
21 of the petition, my lord.
Page 21.
Page number 21. It is to inform you that on 24th July 2010, at about 1940 hours, when I was returning to home from the Officers Club, Bomdila, after playing a group boys, about 5 in numbers, headed by Kiran Rijiju, with deadly weapons like iron rod, daws, etc., have attacked me all of a sudden near Hotel Samurai of Bomdila Bazaar without any provocation and reason. In fact, they were attempting to make me disabled permanently, as a result of which I have sustained severe injuries on the vital portions of my body. The said group continued to assault me till I fell down on the road, almost unconscious. It was not the end of the episode, my lord. It was not the end of the episode. The said group, equipped with a deadly weapon thereafter, went to my house and have attempted to cause extensive damage of my house and household properties. In the process, they have uttered all untrue words at my family members, knowingly that no male members of the family was present at the house at that point of time. But somehow the house could be saved. Then again, the said group came to the hospital with the aforesaid weapons and searched me where I was receiving treatments with intention to cause more injuries and restrain from me from taking treatment. Under the above circumstances, I would like to request you to take legal actions. Basing on this FIR, my lord, the FIR was registered under section 341, 324, 452, 427, and 506.
Okay, where have you annexed the last order?
Last order, my lord, is in page number 42.
Charge is it under the same offense?
Yes, my lord.
Okay, 324 and 448.
Yes,
is non-valuable offense.
Non-compoundable offense. Otherwise, my lord, this offense was taken 15 years back. This offense was taken place 15 years back. 15 years back, my lord.
Oh, 15 years back?
Back, my lord. At that point of time, my lord, almost all the accused were either minor or.
It was before the executive magistrate then?
At that point of time.
Then it was transferred to judicial magistrate.
My lord.
Then the last order is at page 42.
42, my lord. And if my lord may kindly have page number 29.
Just a minute, sir. This last order. Okay, charge already framed.
Yes, my lord. Accordingly, charges has been framed under the so and so sections.
It's for
Whether
evidence
any attempt to for discharge made any prayer?
My lord, I think they have not made any prayer for discharge, my lord.
So directly they have approached this court?
My lord. In fact,
could have, because this is in the 15 years back.
15 years back. They were, in fact, I think, my lord, there would be a dispute of.
There's a problem that the people straight away approach the High Court still without making any effort there.
My lord,
at the time of framing charge, they could have made
they might have attempted, my lord, but since the charges have been framed already.
No, at the time of framing of charges.
My lord.
Because this is the old case of 15 years back.
My lord.
Now, recently charge has been framed in the case 24. So discharge application could have been placed.
They should have, my lord. But since that is altogether in different aspects, my lord, this is not on merit before my lord. We are all together on the basis of a settlement agreement, my lord. That is
settlement agreement after the framing of charges.
My lord, 3rd day of February 2025.
25.
My lord.
Okay. So,
and the injury, my lord, injury report, if my lord may peruse, is simple injury, my lord.
Simple.
Page number 29, my lord. And page number 30 is the observation, my lord. The nature of the injury is simple, my lord.
You have any objection?
Lordship, as they have already settled an injury is also simple lordship.
Simple injury.
Yes, lordship.
Okay.
Then no objection.
Okay. Hard Mr. J. Sirin, Land Council for the petitioner. Also hard Ms. L. Hage, Land Additional PP. I'll take the initial notes. Okay, start. This is an application filed on section 528 of the BNSS 2023. Praying for quashing of criminal proceeding. The quashing of the GR case number 04/2010. Yes, 2010, huh? Arising out of Bomdila PS, which PS case?
My lord.
Which PS case? Bomdila PS.
Bomdila PS case. my lord.
Bomdila PS case number 18, 2010, under section 341, 324, 452, 427, 506, 34 of the Indian Penal Code, pending before the court of the Chief Judicial Magistrate, Bomdila, West Camel District. The petitioner, who is the informant?
Petition number 1 is the informant.
Hmm?
Petitioner number 1.
One is informant
Informant.
and accused.
Accused.
The petitioner number 1, Sri Prem Lundu, is the informant. Semicolon. The petitioner number 2, Harbo Seongju, comma. Petitioner number 3, Sri Kiron Rijiju.
Yeah.
This is some other. There is
No, not
okay. The petitioner number Sri Lulu Rijiju. Petitioner number 4, Sri Langho Seongju. Petitioner number 5 are the accused in the aforesaid Bomdila PS case number 18/2010. The case of the petitioner is that where was the FIR?
FIR, my lord, is at page number
Okay, based on
21.
the written FIR lodged by one Prem Lundu, huh? On 25/06/2010, before the OCPS Bomdila, alleging therein that inter alia alleging therein that on 24 July 2010 at about 1940 hours, while he was returning home from the Officers Club Bomdila, a group of boys, about 5 numbers, headed by the petitioner number 3, petitioner number 3, equipped with deadly weapons like iron rods, dowels, etc., attacked him all of a sudden near the Hotel Samurai of Hotel Samurai, Bomdila, without any provocation. As a result, he sustained severe injuries on his person. Start. The group also went to his house and had attempted to cause damage to his house and household properties. But somehow the house was saved. Start. based on the above written FIR, comma, the aforesaid Bomdala PS case number 18, 2010 was registered under section 341, 324, 452, 427, 506, 34 of Indian Penal Code. Stop. And investigated into stop. Para. Upon completion of investigation, comma, the eye of the case laid charge sheet against the accused number 2, 3, 4, and 5 for commission of for commission of offense punishable under section same 341, 324, 452, 427, 506, and 34 stuff. After taking cognizance, the learned Chief Judicial Magistrate framed charge against all the accused petitioner number 2, 3, 4, and 5 for offense under section same 341, 324, and so on 14/3/2024. Starting. The matter is still the matter is at the stage of evidence stuff. However, in the meantime, the parties have settled the matter outside the court by executing a deed of amicable settlement agreement on 3/2/2025. Stuff. The settlement agreement includes that the matter has settled amicably and the informant stroke victim doesn't have any further grievance against the accused petitioner number 2, 3, 4, and 5. The method this would be installed with that the settlement agreement includes that the informant petitioner number 1 lodged written FIR against the accused petitioner number 2, 3, 4, and 5 due to serious misunderstanding resulting the registration of case and subsequent charge sheet stuff. The charge sheet, it further includes that the accused petition number 2, 3, 4, and 5 tendered an unconditional apology from the informant petitioner number 1 for creating such misunderstanding and the informant petitioner number 1 expressed that he has forgiven the accused petitioner number 2, 3, 4, and 5 for creating such misunderstanding stuff. And since the party has already amicably settled, the accused, sorry, the informant petitioner number 1 does not have any further grievances here to come against the accused petitioner number 2, 3, 4, and 5. The agreement further contains that the informant petitioner number 1 will extend all cooperation for discharge stroke acquittal of the accused petitioner number 2, 3, 4, and 5 from the aforesaid GS number 04/2010. Aforesaid G, okay. That's fine. Then these are the facts.
Yes.
Okay, then rest will be taught. Go back. The case of
It's only
that yesterday's that case will cover. Okay. What is this?
just for inclusion for the report, madam. Is Rahul Gupta's judgment. The last part, just short one.
Then the land council for the parties, in support of their submission, that one, and then here, where this one para?
Para last paragraph. Madam.
This I think is different. Charge yet to be framed. Here in this case, in the instant case, the charge already framed.
Yes.
No? Last para means para 17.
Yes, madam. Just only to show that, my lord, if the settlement has been done, only to maintain harmony, my lord, the interference can be done.
The victim and the one as well. Okay.
Leave it.
That's correct. Okay. Dispose. This is item. Yeah. Yes.
Item number 28.
Yes.
I'm appearing on behalf of my senior counsel at Rama.
Criminal petition.
Service not completed, awaited for the service report. May await for the service report.
Service report still await upon, service upon,
Respondent number 2, my lord.
respondent number 2.
Yes, it's a matter on merit, my lord, not on settlement.
Okay.
It's on merit. Yes, sir.
Yes, has been made party,
Yes,
the informant. Then in that case, service is to be complete. Okay.
yes. Await, your lordship,
Mr. Miss, you are Mr.
Kitechi.
Hmm?
Kitechi.
Okay, then counsel for the petitioner is present, Mr. Tete. Then additional PP is also present, staff. The service report, service upon the respondent number. The service of notice upon the respondent number is still awaited. In view of the above. List is matter after 2 weeks,
Maybe 3 weeks, your lordship.
3 weeks, after 3 weeks. Okay.
Obliged.
Lordship, TCR has been received, so Lordship, this matter may be fixed for admission hearing, Lordship.
Listed for admission.
Yes, Lordship.
What is this matter about? Washington.
Washington.
Scan copy received.
Scan copy of the TCR receipt, Lordship. TCR lordship.
TCR received.
It
Okay.
may be fixed for admission hearing.
Okay, so both the land council for the parties are represented that trial court record has also been received. In view of the above, let the matter be listed after 3 weeks for admission. Okay. Yes.
Here, your lordship, they were directed to file an affidavit.
We have not filed, Lordship.
Not yet.
Yes, we need some more time to file the affidavit.
Miss
And Hondik. And Hondik, Lordship.
on the Land Council for the petitioner.
Yes, Your Lordship.
Petitioner is to file affidavit.
Yes. Your
What
Lordship.
affidavit?
My lord, your lordship will find the order of this honorable court, your lordship. There, your lordship, actually, we have initially made an objection that on piecemeal basis, the case cannot be quashed. So that part has been kept open. And the second part is, your lordship, they have submitted that the other co-accused who has not been made party in the agreement, they have been tried before the JJB court.
Okay.
So this honorable court has directed them to bring on the record the proceeding before the JJB by way of additional affidavit.
So by which order it was directed to file affidavit?
Order.
Or was the proceeding stage?
Order dated 10.
Affidavit, okay, 19.
Yes, your lordship. It's on
Affidavit, okay.
on 10/3, my lord.
10,
10/3/2025, your lordship.
10/3 or 9?
Yes. 19, it was adjourned.
10/3/2025, my lord will find in.
10/3 itself.
Yes, your lordship, on the very first day itself.
Okay, very first day.
Yes.
In the meantime, the very confined for the people.
The petitioner will.
Okay, additional, just a minute, constant.
Second last paragraph, my lord. Third last.
In the meantime. Sorry, okay. Miss, her name. Praise for father. How much time you said? 2 weeks time?
2 weeks, Your
2
Lordship.
weeks time to file affidavit, additional affidavit. There is affidavit in the matter. Stop. For the ends of justice, the prayer is allowed. List this matter after 2 weeks. Mr. Additional PP is present on behalf of the state. Stop. The interim para list this matter after 3 weeks. 3 weeks, no?
2 weeks.
Oh, after 2 weeks. Stop. The interim order passed earlier shall continue till the next date of listing. Okay.
Oblige.
If you oblige, Your Lordship.
Your Lordship, this criminal petition has jointly been filed by 2 numbers of petitioners. Petitioner number 1 is the alleged accused. Your Lordship.
Yes.
Your Lordship, this criminal petition has jointly been filed by 2 numbers of petitioners. Petitioner number 1 is the alleged accused, and petitioner number 2 is the informant. The petitioner number 2 is wife of the deceased. The sections which have been charged against the alleged accused are 279 and 304A IPC. 279 is for rash driving or riding on a public way. Punishment is 6 months, Your Lordship. And 304A for causing death by negligence. Punishment is 2 years. Your Lordship, the fact is that on 5/2/2024, at around 8 p.m., the petitioner number 1, while returning from Teju to Kakopothar, Assam, had hit the deceased with his car, who had gone to the market to buy meat. And the petitioner number 1, on fearing that people would gather and attack him for causing the incident, he did not stop his vehicle and kept on driving. And when he reached near Digaru check gate, he was apprehended by the police along with his car. Subsequently, FIR was lodged by the informant, who is the wife of the deceased, and it was registered under section 279-304 IPC. Initially, it was 304 IPC, but after investigation, it was found that the accident had occurred due to low visibility, which was caused due to heavy rainfall and dark colored clothes of the deceased. So 304 was found not well established, and it was charge sheeted under section 279 and 304A IPC. The Lordship, the matter has amicably been settled between the petitioners. In this regard, deed of settlement
And the compensation amount has already been paid to the deceased family. So accordingly, this settlement was executed by the wife of the deceased and the father with the accused.
Also filed
This is a joint petition, man.
Then what I'm saying is the accused petitioner is will request
Funeral also, he has paid the amount.
during
Time of funeral of the
Okay,
deceased.
paid only.
Yes,
At the
ma'am.
time of
Page 32 is the first money received. 32, my lord, yes. And 33 is the payment made during funeral. And 34 is the final payment of 5 lakhs remaining.
whether record was called for here.
Yes, it has already received.
What is the stage of the file?
It's fixed for evidence. I have page 55, my lord. I have
Evidence?
put the, yes. He is about to start evidence. Charge is
Not yet
with-
started.
Not yet started. Page 55 is the last order of the learned trial court.
55 of your petition.
Yes, 55 of my petition.
Any MACT case filed?
Since they have settled, my lord, with the payment, no MSCT case has been.
No,
I've not
the
received the
vehicle,
notice.
the offending vehicle must have been registered.
Yes, my lord.
Was it registered?
This case was registered, my lord.
No, this is the case, but
Yes.
then whether the offending vehicle was, I mean, insured.
As per the charge sheet, my lord, it was insured.
Okay, charge framed.
Yes, my lord.
Trial comments, my lord, already. And for PW, the date is fixed on
So what, under the 304 can also. be
304A, my lord. Initially, actually, what has happened? The FIR was registered under 279 and 304. But later, but I think your lordship only one will work because
Yes,
the
yes.
Smith has been referring the other one. Yes, your lordship. I will furnish it, your lordship.
Furnish and then mark the highlight
Yes, your lordship.
or the flag in the
Okay.
relevant portion,
Okay, your
relevant
lordship.
paragraph.
Okay, okay. All right.
So since the parties have settled and adequately compensated, I think
Yes.
no point.
Yes, your lordship. It's better to quash the matter, your lordship. I will furnish a copy, your lordship.
Okay. This will also go in the same way, huh? Mr. Chetri, line counsel for the petitioner, also that Mr. Line additional PP for this respondent, staff. Then the para, the petitioner, this is a joint petition.